through Article 5 of the U.S. Constitution. Could you, before you get into this amendment, could you back up and tell us with specificity what is in Article 5?
Well, I read it earlier. I'll read it again.
Oh, yeah, but I'm trying to get to a point here. As far as how that would work in practicality, if a convention was called, are there any sort of set rules or anything like that? Does it have in our Constitution that, you know, one state, one vote things? Could you walk through those sort of things for us?
Well, when you get to 34, when you get to 34 applications from 34 states, then a convention is called, and Hamilton talks about it here in Federalist 85. He says, the words of this article, or Article 5, are preemptory. Nothing in particular is left to the discretion of Congress, really, is what he's saying, except to honor the call, and then they propose whether the ratifications occur by the General Assembly in each state or by convention in each state.
And how that's voted. So in other words, we don't know until the convention is called what the rules of the convention are going to be. Is that a fair statement?
Well, the convention would adopt rules, although we do know that it is normal.
We currently don't know going into the convention. We don't have any idea what those rules are going to be.
We know that historically, conventions that have ratified the U.S. Constitution, we have 12 examples of that they were limited to the ratification of the Constitution as presented by the Constitutional Convention, and then they disband. And so we know that there is a rich history of what conventions do, how they behaved, and they stuck to the subject matter and to the limitations.
But those rules were written when they arrived, so you're just going based on history. Has there ever been an Article 5 convention called?
No, there hasn't.
So we're plowing new territory.
We came close,
and
we came close in 1911.
We came close, but we've never done this before.
No.
And we don't know what the rules are.
We would, by agreement of the states, agree upon the rules, but you would be limited to the subject matter of the call. And there are calls for balanced budget amendments. There are calls for
Senator, where is that?
Senator, I'm answering your question. There are calls for balanced budget amendments. There are calls for Article 5 amendments and for multiple other amendments. And to call a constitutional convention, it has to be the same application, not a different application, which means you've got to deal with only that one subject matter that reached the 34 state threshold before you call a constitutional convention. It's not wide open about anything that you want to change in the Constitution. Is specific about what you passed an application for. If it weren't that way, we would already have a constitutional convention having been called, because there are more than 34 collectively, there are more than 34 calls for various reasons: a balanced budget amendment, a convention of states dealing with the three issues that this resolution is dealing with: term limits, limiting the federal power, and fiscal responsibility. If you put those two together, we're way beyond 34, but no one has argued or even attempted to advocate that there is a convention that has been called, constitutionally duly called, because it's reached the 34 state limit. So that's self-evident. That's evidence that you don't combine all these calls irregardless of the subject matter. The call is limited to the subject matter you call a convention for. And that's the history of conventions in this nation as well.
I understand history, Senator, but just as you said earlier, we've never had an Article 5 convention. So in this, it says to impose fiscal restraints, to limit the power and jurisdiction of the federal government, and to do things with term limits. So what I was getting at is, what mechanisms are in place, or can you assure us that nothing else will be, as broad as those are, that nothing else would be dealt with? Where is that in,
Well,
in the Constitution or in statute?
Well,
or
biggest, a very big safeguard is the 3/4 state ratification requirement. 75% of the states have to ratify it.
And that would be one
So if you
state, one
do
vote?
something crazy, you're not going to get 75% of the states ratify it.
And that would be ratified by the general assemblies of each state?
By the General Assembly or by convention in the states.
Okay. In a minute, I want you to talk a little bit about that convention in the states. But I have, well, you could do it now if you like.
Well, we have a history of that. Again, that's the way that the U.S. Constitution was ratified primarily, is by conventions in the states. And we have a very robust history. And again, Pauline Myers' book is probably the best book written on it.
Senator, did you know that putting fiscal restraint on the federal government, I'm a big believer in. I mean, I've been saying this for years. They're borrowing and spending like a bunch of drunken, well, you know where I'm going with that. And I'm a firm believer in term limits and also in restraining the federal government. Everything I think that we're trying to accomplish here, I believe in. I just want to make sure that we all understand this process, the safety rails that are involved, and that we all feel good about this safety rail. So I'm going to take my seat now, but I'll have some more questions for you later on.
Senator, you mentioned the federal fiscal responsibility. This is hot off the press, just at least not, well, 2020 anyway. In 2020, the national debt as a percentage of the U.S. economy was 130% of GDP. That's higher than it was during the peak of World War II. It was less than 120, about 127. It's 130 or 35 now, and that's a 130% increase since the year 2000, when it was only 65%. So if you're talking about the need for some fiscal restraint, that tells the story right there. In fact, the amount of debt per household, the total federal debt is $3.1 trillion with a T. That's $233,000 for every household in the nation.
Right. And Senator, I don't disagree with you. And
how many households do you think can stroke a $233,000 check to pay off the national debt?
I know your household probably could, and I know mine probably couldn't. But Senator, thank you for bringing that up, because you're talking about the debt. And that reminds me of when I was in 10th grade of high school. I took a political science class. And our teacher was a very sweet lady, about this tall, blonde. She had the little John Lennon glasses, and extremely liberal. And myself and or a goodly number of my classmates were extremely right-wing, conservative Republicans, Ronald Reagan supporters. That was on the time of the Reagan election and re-election. And so we were arguing because President Reagan was having a fit about the deficit at that time. And we were arguing to her what a big deal that was. And she looked at us and she said, well, that's the national or the federal debt. But she said, it's money that we owe ourselves, right? It's money that we owe ourselves. So what difference does it make? Which I thought was the most ludicrous statement I'd ever heard. So, I mean, I'm not in disagreement with you over that. I mean, a lot of countries own our debt. A lot of citizens own our debt. I think, correct me if I'm wrong, but here lately, the largest holder of our debt is the Federal Reserve System. Is that correct?
Well, you've had both monetary policy and fiscal policy create this problem, and the Federal Reserve buys a lot of it, right, and they engage in market activities in order to manage and control interest rates. They do that.
So the Federal Reserve is holding a lot of our debt, and came in and propped up the economy. And do you know where the Federal Reserve gets their money? Do they work and earn money?
Well,
Is it a
they
bank?
basically, it's
Is it-
fiat money for them, Senator.
Exactly. They just print whatever they need. I was astounded when I heard the chairman of the Federal Reserve say that their resources were unlimited. I mean, we all know that they just print money out of thin air and oftentimes give it away.
But what does that
Are
do to your money, Senator?
Sir?
What does that do to your money when they expand the money supply, whether it's through fiscal or monetary
Listen, it
policy?
makes my purchasing power drop. And what's going on recently is absolutely killing the senior citizens and those that don't have earning potential anymore in this country. So I'm 100% on board with stopping the government overspending and our debt. But I'm just trying to get some sort of comfort level about opening up the Constitution of this nation for changes that may not be reflective of my values.
Well, Senator, this is a device the framers gave to the states as one of its most powerful weapons against the federal government. And to simply refuse to ever use it is tantamount to unilateral disarmament, because it's very powerful, and the federal government has, over the years, has accumulated more and more power at the state's expense. I think you agree with that.
Oh,
and so this
certainly.
is not something you take lightly. You know, it is something that for desperate times, but we're probably in that category, in that territory.
I would agree with you. And I have some more questions later, but thank you, Senator.
Thank you.
Senator from Orangeburg, Senator Stevens, what purpose do you ask?
Thank you, Mr. President. Senator, yield for a couple questions.
Yes.
Senator yields.
Senator, do you know that much of the opposition to an Article 5 convention has come from dangerous and unpredictable what may actually occur at the convention, and especially during a toxic atmosphere that we live in now? Do you believe that that is some of the reasons for opposition to a Article 5 convention?
The toxic political atmosphere?
Yes.
Yes, I think that is source of some of the opposition, yes.
As well as an unpredictable convention itself?
I think that's a little overstated. Again, I've spent some time really studying the history of conventions, and if you really study the history of conventions, and if you had a judge on the Supreme Court, if you had the judges on the Supreme Court preside over a case, is this a runaway convention or not? And I'd like to say this, I started out being opposed to an Article 5 convention and studied my way to be in favor of it. So I started out on the other side of this ledger, and
Senator,
I studied myself to be okay with it. And historically, if you had the Supreme Court who heard a case about this was a runaway convention, and they looked at the history of conventions, I don't think there's any question that they would draw the conclusion that a convention that is called for a particular purpose must stick to that purpose. And if it doesn't stick to that purpose, then it was not a legitimate convention. That's number one. Number two, the 75% ratification is the most significant. That's a big, big hurdle to overcome. 75% of the states in this nation to agree upon something.
but is
It's not something runaways not going to be agreed to by 38 states in the nation.
Senator, is there anywhere in Article 5 or the Constitution that authorized Congress, state legislators, or anyone else to limit the agenda of the convention?
Well, Article 5 does say that, let me find my,
And while you're trying to find that, Senator,
it does say that 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 the state, on application of the legislatures of 2/3 of the states, shall call a convention for proposing amendments, in which case shall be valid to all intents and purposes as part of the Constitution when ratified by the state legislatures of 3/4 of the several states, by conventions in 3/4 of the states. So it's ratified by either the legislature or conventions in the state. And as far as Congress goes, they can propose whether it's convention or the legislature.
But
That's what Article 5 provides.
Is that truly saying limit? They are actually just limited to what the state legislature proposed to Congress as the reason for the Article 5 convention.
The limit on the subject matter is already being applied to this, because if there were no limit to the subject matter of a call for a convention of states, we would already have one. Because if you add up the balanced budget amendments, the Article 5 convention of state amendments like the one that's before us, you would already have reached the 34 state threshold for a convention to be called. So we have already, as a matter of practice over the course of decades, not applied the very thing, the principle that, or concept that you are concerned about. That we have not applied that, because if that were applied, we would have already had a convention of states called.
Well, Senator, did you know that the Supreme Court has made clear that the process of amending the Constitution is a political question into which courts would not intervene?
Well, courts could intervene in the process, not what the subject matter of any amendment adopted is, but they could, it would be something squarely within their jurisdiction to rule over whether the process by where that amendment occurred was in accordance with the Constitution or not. That they clearly would have jurisdiction over.
Senator, I thank you, Mr. President. Senator, I do have some other questions I'll ask later. Thank you.
Thank you, Senator. Senator from Spartanburg, Senator Kimbrell, what purpose do you ask?
Mr. President, see if the senator from Charleston would yield for a few questions.
Yes.
Senator yields for questions.
So Senator, I've listened to your explanation, and I remember our discussions in Judiciary Committee. And do you believe all this talk of a runaway convention? We've heard a lot of people talk about it, both inside this body and out. I've thought about it a lot. But doesn't it bear pointing out that this, and you've said it already, but I want to say it again, the notion that we can just go shred the Constitution is overblown, because the ratification process is not suspended, right? We're not suspending the process whereby the states ratify any proposed amendments from an Article 5 convention.
That is correct. Three-quarters.
The ratification process is still in place.
38 have to ratify. That's correct.
So, for example, and I think, and I would share this concern with the senator from Greenville and other folks, that, you know, people talk about the Second Amendment might be at risk. If you had to politically be Nostradamus for a moment, do you think you could get 38 states of these United States to shred the Second Amendment?
There's no chance that would happen.
There's no chance that would happen. I wouldn't vote for it. You wouldn't vote for it. This state wouldn't vote for it. Do you believe, I've thought about this a lot and read a lot of literature from the founders on this issue, and I've heard people almost imply that an Article 5 Convention of States is sort of like a self-destruct mechanism. It's like when you have a plane that crashes many lines and you push a button and it kind of destroys itself. I don't think the Madison and the founders had any idea of this being or any intention of this being a self-destruct button, right? Isn't this a self-preservation relief valve? I mean, do you believe, Senator, that the founders are more concerned about a runaway federal government than out-of-control state governments?
Oh, they were more concerned about a runaway federal government. And the federal government has only become much more powerful, really by judicial fiat, than the government that the framers created. There's no question about that, which argues for a Article 5 convention to restrain federal power, because federal power has been increased dramatically.
Senator, I had someone come to my office and tell me, and I found this to be interesting. I'd like your take on it since you chair the subcommittee on this, on Article 5. They said, well, Senator, you have to understand Article 5 is an outdated concept. It's never been tried before. Therefore, it's outdated and we shouldn't follow it. I was a little bit stunned, and I kind of, I asked the question. I said, well, it's in the original Constitution. So if you say that Article 5 is outdated, aren't you essentially saying that the Constitution is outdated? I mean, I disagree with that. I think the Constitution is timeless wisdom that's still applicable. But Article 5 was in there in the original version. It's not an amendment that was added later, right?
Well, that's correct. And Hamilton in Federalist 85, we may safely rely on the disposition of the state legislatures to erect barriers against the encroachment of the national authority. What I'm telling y'all is the more you read the founders and the framers, the more you understand they put this in here for the benefit of the states to push back against federal overreach and that disrupts the balance of power. I don't want the states to be too powerful either. I think it's important to have this balance. Like the separation of powers balance is important, federalism balance is important. And the framers had the idea that we put this in here for the states to push back if the federal government, in Hamilton's terms, the states could erect barriers against the encroachments of national authority. And so at the end of the day, that's one of the most significant things that struck me. The framers put this in here as a sword for the states to pull out and use if federal power and encroachment of power became too great. And I believe that is true. I think it is a tool for that purpose. And for us to unilaterally disarm and say we will never use it is really taking one of the most powerful tools the framers gave to the states under federalism doctrine, take one of the most powerful tools and unilaterally disarm. I've used the analogy, it's an arrow in our quiver. I'm a bow hunter. When I pull an arrow out my quiver, I want to shoot it at something. I don't want to throw it on the ground. That's unilateral disarmament. And for us to say we will never do this, in the eyes of the framers, I'm totally convinced. They would say you are unilaterally disarming. You are discarding one of the most powerful devices we put in the Constitution for you to push back against federal overreach. And that is the mind of the framers. I mean, I don't think there's any question about that if you look at the history. And is there some risk involved? Yes, there's some risk. I think the biggest mitigation of that risk is the 38 state ratification requirement.
Well, and Senator,
I can think of any number or combination of 12 states that would not let something really crazy happen.
I would agree. And to your point, when you mentioned this is the mind of the founders, I heard a joke once, and I thought they said it sunk tongue in cheek, but it's true to our times. They said, what would the founders think if they came back to 21st century America and they looked around and saw how things were going, and someone said, well, they'd start a revolution and start their own country. But they wouldn't have, because they built Article 5 in to avoid having to have another revolution. It's almost a political revolution of sorts built into the Constitution, as you put it, checking power not only between the branches, but between the federal and the states. So the last question I have, because we've had it brought up already today, this idea of, is there a prescription, so to speak, on what we're going to address in Article 5 convention? And it's my understanding that if we adopt this resolution, and I certainly hope we do, we'd be the 19th state to do it. So 18 other states have. Virtually every state that has done this has followed the same template of saying that this convention will be for purposes of proposing amendments dealing with the jurisdiction of the federal government in the areas of term limits, of balanced budget amendments that would reduce or limit the jurisdiction of the federal government. So aren't we just basically using one of the two prescribed ways to propose constitutional amendments anyways, because Congress is never going to vote for term limits, and they're never going to limit, they're never going to have a balanced budget amendment. We're saying here, this is a tool for us to make Congress consider, or the states consider, amendments Congress would never do on their own, right?
We are, Senator, and if we unilaterally disarm and never do this, the federal government in Article 5 has the ability to amend of course, they let the Supreme Court do it, really. They've let the Supreme Court do it basically by the living, breathing Constitution concept. But if we refuse to do it, then we're just letting the federal government be the only one who can play in that sandbox. And for us to say we will never do this when the framers considered it one of the most important devices we have. And I would be, again, I studied myself from being opposed initially to being supportive because I saw how significant the framers considered this to rebalance the power between the federal and the state government, and they were very, very committed to balanced political power, not excessive political power, because we are seeing today, when you go home and you turn on the cable news and you see what's happening in Ukraine, you see the consequence of concentrated political power vividly. And the people of Ukraine are living it and dying it today as we speak. The framers they were not all Jewish or Christian, but they did have a Judeo-Christian view of human nature. Because you develop that view of human nature, whether it's by theology or experience, you develop the same conclusions, and that is that man is made in God's image, or if you don't even believe in God, man is capable of good. As a Christian, I think because it's made in God's image, but man's capable of good by observation. You understand that. He's also capable of great evil, because we see that. In a Christian theology, and Jewish theology, man is fallen, sinful, fallen from grace. But what do you do with a creature like that? What kind of government do you form? You form a government, and what kind of culture do you create? What kind of value system do you create? I'd say you create guardrails. You create guardrails in the form of law, in the form of a constitution, in the form of values and institutions that develop over the centuries through the crucible of human experience, like the law of natural selection in the natural realm that always produced the best results, because if you do things wrong in the natural realm, you get eaten by something else. And so you pass on these behaviors and patterns that lead to success in a species. The same thing happens in the human species. But it is as capable of great good. He's also capable of great evil. We're seeing evil today vividly, and we are seeing good today vividly, and they are both, and no one can deny that human nature is capable of both in the extreme. We see it. If you don't believe it, go turn on the news tonight when you go home, and you will see both good heroism, bravery, and tremendous evil. And that is the nature of man. And so you have to create institutions, and you have to create a form of government that restrains the evil and promotes the good. That's why value systems are important. That's why civic organizations are important. They create the guardrails, they promote the good, and they restrain the evil. And that's what's needed. And the framers understood that. That's why they separated power and not concentrated it. And this is part of separating that power. They gave to the federal government the right, the ability to amend the Constitution. They've done it a few times. And they gave to the states the ability to amend the Constitution. And in the framers' mind, that was exactly the way they did everything else. We're going to diffuse political power, give some here, not concentrate it. And the notion that we will never do this is basically just unilaterally disarming.
Well, and Senator, it's like, so essentially what you're saying is what the Federalist Papers said, and that is that if men were governed by angels, there'd be no need, or if men were angels, there'd be no need for government. If men were governed by angels, there'd be no need to govern the government. Since neither is the case, constitutions are implemented among men. So I appreciate your work as a bow hunter to help put this quiver in our pack, so to speak. Thank you, Senator.
Well, that's Federalist 51, Madison, my favorite quote of all. And it's the most provocative of all. And he said that, and so why do I say that the framers had this view of nature, which is tantamount to a Judeo-Christian view of nature? James Madison said it in Federalist 51. If all men were angels, no government would be necessary. If angels were to govern men, no restraint on government would be necessary. In creating a government of men, over men, the great difficulty lies in this. First, you must empower the government to restrain the governed, because they're not angels. Secondly, you must compel the government to restrain itself, because the government's run by people who aren't angels. We're seeing that. Aren't we seeing that today in Russia? Aren't we seeing that there hasn't been the restraint on government that's needed? We're seeing that today vividly. For those who think evil doesn't exist, they're getting a little lesson, aren't they? Unfortunately, a big lesson.
Senator from Orangeburg, Senator Stevens, what purpose do you rise?
The senator from Charleston yield for two more questions.
Two more what?
Two more questions.
You promise?
Promise you.
Okay.
This day.
Senator yields for two more
You can
questions.
take more if you want.
Yeah.
I won't limit you.
Senator, do you know that once delegates are selected to an Article 5 convention, they become federal authorities, and that the states no longer have control over their say-so once the convention has convened?
Well, Senator, we have a bill that comes after this, which requires the delegates to follow the call that the state issues and not deviate from that subject matter, with criminal penalties involved if they do. That's number one. Number two, so that's a bill that's going to come. If we pass this, we're going to offer a bill, and hopefully we would pass a bill that makes a delegate swear an oath, and if they violate that, then they'd be subject to up to 5 years imprisonment. That's number one. And number two, it's the 3/4 state ratification provision that really is your protection against that type of, quote, runaway convention.
But is it enforceable if they become federal authority?
Yeah, yes, it is. Yes. Because, we elect a delegate from the state to go to a convention of states, and they're subject to state law. Under state law, they're subject to limiting their votes and their support in the form of votes for the items that are listed in the application. So that would be enforceable under state. I don't know any reason why that would not be enforceable under state law.
But in a court ruling, it states that back to once that individual has been selected, that they are that federal authority. And state officials who are elected, for example, our U.S. senators, we cannot control their do's and don'ts. Am I correct?
You used to be able to, pretty much, before the 17th Amendment was adopted. Because before the 17th Amendment in 1911, U.S. senators were elected by the state legislature. And you know what? They listened, and they were really protective of state concerns when they were elected by the state legislature. When that went away, not so much.
But if you look at a U.S. senator compared to a delegate for a convention, they are basically selected not to do the same thing, but by the state to do something on a federal level. And once that becomes their position, for example, the delegates are now on the federal realm in a sense. And the state, from my understanding, the state can do too much
Well,
about
I
them,
don't,
even.
I don't think I agree with that. It is a convention of states, and the states send delegates to that convention, and the states can put limits upon what their delegates, again, because it is a convention of states. It's not the federal government. It's states forming a convention in order to propose an amendment to the federal Constitution. And so they still are representing the state. It's even called a convention of states, and they are state delegates. So I think you could actually restrain them, and you could actually impose penalties, of criminal penalties upon them if they do violate the directives given by the state legislature in calling for a convention of states. Now, some may disagree with that, but I do think that would be the outcome, because you are not a federal official. You're convening a convention of states in order to propose changes to the Constitution limited to the three things: reigning in federal power, term limits for federal officers, and restraint on federal and fiscal restraint.
Senator, I want to reference and do you know that in a Supreme Court ruling, it was said, and this was Bush versus Palm Beach County Canvassing Board, the U.S. Supreme Court.
The hanging chads case, right? They were dealing with
Yeah.
hanging chads back then.
Pretty much, that when state officials derive their power from the U.S. Constitution, federal law can constrain state officials' action.
Say that again.
When state officials derive their powers from the U.S. Constitution, federal law can constrain states' officials' action.
Well, that would be, and this is about counting the votes in Palm Beach County, the Bush-Gore race.
That is
That was the context of the case. It was the Bush-Gore case.
yes, sir. Take a look at that.
Well,
then we'll
that
talk
goes
about
to
it
the
some more
elections
tomorrow.
clause, and the elections clause, I quoted it earlier,
Yeah.
that the election clause gives states the authority over the time, manner, and place of elections, subject to such regulations as Congress may pass. So again, it's an example of balancing the power between the states. And Alexander Hamilton said in Federalist 53 about this. He said, and again, it's another example. We don't trust human beings with concentrated political power. We're going to diffuse power at every opportunity. That was their view. And Hamilton said it in 53. He said, the power over elections could be given wholly to the states or wholly to the federal government, or primarily to the former, but ultimately in the latter. And primarily in the former, which is the states, ultimately in the latter, which is the federal government, is what's in the elections clause. So because the elections clause, again, the state shall determine the time, manner, and place of federal elections, is what it's talking about, subject to regulations by the federal government. So they were probably talking about things like the Voting Rights Act and HAVA, Help America Vote Act, and other things like that, where Congress has regulated into something that was primarily given to the state government, but the federal government steps in accordance with the elections clause, but it has stepped in historically in relatively narrow places and has demurred from taking over the whole thing. And that is the framework that the framers put in the Constitution under the elections clause. So I suspect that's what that is really referring to. The interplay of the state election laws and Congress is legislating in that area.
My last question, Senator. Is it so that there is a group of individuals and not necessarily state that want to see a limit of power of our congressional leaders, or federal leaders, congressional leaders.
I'm sorry, would you say that again?
Is it actually a group of individuals from across the United States who want to see term limits more so than individual states pushing that effort?
I don't know. I know I see a lot of people that are, as opposed to a group, I see a lot of people that are very supportive of this, and I see some that are very opposed to it too. And I understand, I used to be opposed. And I understand the basis for opposition. But at the end of the day, it is important, the framers considered an important power they gave to the states, and I do see that. And I don't want to just unilaterally disarm and throw away that power and say we'll never use it.
Well, Senator, there are a few groups whose supporters of the Article 5 Convention, and one of those groups is the Convention of State Project, and they basically there to see that the federal government is stripped of some of its powers. And then there's the American Legislative Exchange Council, which is also supporting that effort. And get this, Senator, there's a liberal group called Wolfpack, and they are in the process of persuading a few blue states to request an Article 5 convention to reform campaign finance law. So there are a number of groups out there that is actually pushing for an Article 5 convention. Did you know?
Well, be honest, Congress could reform campaign finance law at the federal level. You don't, but they won't do it.
And that goes to my point, Senator, that one of the best ways of term limitation is me going into my wallet and pulling out my voter registration card, or someone going in their pocketbook, a person pulling out a voter registration card, and you can limit me to 1 term or to 2 terms, and we don't have to go through a convention to do that. We can do it every election cycle if we do it right.
Well, you do have a series of events that have really concentrated power in the federal government, more so than when the framers created it. And incorporation doctrine, 17th Amendment, a lot of incorporation doctrine applying, the Bill of Rights to the states, which the framers didn't originally have that view, but that was something that was decided. So we've got a lot of decisions, and then you look at the fiscal issue and the national debt. And so there are reasons for concern with the amount of federal power that has been taken from the states. And I don't want the states to be more powerful than the federal government. I really don't. I don't want the state Senate to be more powerful than the House. I don't want the legislature to be more powerful than the governor. I don't want the legislature to be more powerful than the judiciary. I want each branch to have enough power to be like those 3 crabs in a bucket. If one starts getting out of hand, the other 2 have the power to restrain them and pull them back down. And I want equal power so that so it's difficult to get anything done, which is the way that liberty is protected. That's really what I want. And I do think that the federal government has gradually accreted more and more power over time. And I doubt anyone would really disagree with that. Now, we may disagree on whether it's appropriate or we've crossed some kind of line or not, but that has definitely happened since the framers first created.
Thank you, Senator, for the dialogue. Thank you, Mr. President.
Yes, sir. Thank you, Senator. Senator from Greenville, Senator Corbin, what purpose do you rise?
Senator, answer a couple of questions.
Senator Yield for a
Yes.
couple of questions. Senator Yields for questions.
Senator, I appreciate that. At some point in time, are you going to ask to adopt the committee report?
Yes.
Okay.
Yes.
Um,
I'd like to do it sooner than late rather than later.
I'm just testing your endurance, Senator. It's,
Well,
yeah,
I'm not
I feel-
filibustering this bill,
I feel
Senator.
privileged. It's rare that you go to the podium. So I know
Oh, it
you're
is?
passionate about this issue. In the original House bill, I suppose 3205 is what we worked off of. And then you're going to move to adopt the committee report. And in the original House bill, in section 2, number 5, it says here that the convention of the states pursuant to this application must be limited in consideration to the topics specified in the joint resolution and no other. And it says this application is made with the express understanding that the amendment that in any way seeks to amend, modify, or repeal any provision of the Bill of Rights, which would include the Second Amendment, 13th, 14th, 15th, and 19th Amendments to the United States Constitution shall not be authorized for consideration at any stage. Can you tell me why those guardrails were stripped out of the amendment and left out of the committee report?
Because the original bill was prescribing certain things that Congress must do, and you can't do that. And also, if you have
But Senator, that wasn't part
the
of it.
state, we can't direct Congress to do certain things. We don't have the ability to do that.
But Senator, that
And so
just that wasn't directing Congress to do anything.
Other parts of that original language was.
But I know, but I'm
and
just asking why this particular piece, this safeguard was stripped out.
you think it's because I'm an opponent to the Second Amendment, Senator?
No, sir, I
Well,
don't.
I'm
I
not- it's
know
not
you're as
because of
big
that,
an
I can
advocate
tell
of the
you
Second
that.
Amendment as I am, but I just would like a legitimate answer as to why.
You don't
certain
seem to like
safeguards
the
were stripped
legitimate
out.
answer I'm giving, but the applications need to be the same. If you count up the applications, you got to have 34. If you have different applications addressing different issues, then you're leaving yourself open to a court concluding that those are separate applications and different. So that could make our application the first application instead of the 19th application on a new application for convention of
Senator,
states. So that's number one. And number two, most of that House language was stripped because it was in fact telling Congress what they shall and shall not do. And you can't do that, and you're making this subject to a court setting it aside if you do that.
So, and I understand.
And number three, the chance of 13 states removing the Second Amendment is infinitesimally small, to where it's non-existent. And the application on its own limits it to, the amendment limits it to three things, and that is term limits for federal offices, fiscal restraint, and reining in federal power.
I understand
and
that.
None of those have to do with the Second Amendment.
Well, I understand that, Senator, but you understand my point as well. So I would assume
That would be superfluous to put the Second Amendment language in there. It's not needed.
Well, I understand, but
It's already
as-
limited
as
to
I
things that
stated
don't
earlier-
include the Second
As I
Amendment.
stated earlier, did you know, Senator, that was not telling the federal government what to do, which boasts some.
Well, other parts of the amendment of the
right.
original bill were.
Right. So I understand that. That's not what I asked about. But Senator, that was my another question I had. It was my understanding that every one that was passed had to be the exact same verbiage. Is that correct?
Well, not exact, but you're safer for it to be exact. But at least arguably addressing the same subject matter, the same call. But if you get, it's in the eye of the
So
beholder.
if certain
It's in the eye of the
guardrails,
court.
if certain guardrails were left out of the other states that perhaps weren't thought of, and we thought of them and put them in, then we have to take out what the House did in order to have this go with the ones that are.
Well, it's
of
better
like verbiage.
if you want to be successful at this, it's better to have the same language, or at least similar language, and the same subject matter, and not additional or dissimilar subject matter, which is probably where you're really running into trouble if you have different topics or different subject matter. Probably that's where you're not going to be counted as the same application to reach the 34. And like I said, if that does matter, otherwise we would have already had a convention of state called because we have more than 34 applications. The subject matter is just different.
Right.
And you can't, and what the original language also did, which I know you didn't address this, but one reason we amended it is that the original language basically commanded or directed that Congress do certain things, and we can't do that under the concept of federalism. That we can't direct them to do something because we are a separate level of government, and under the principles of federalism, we can't direct Congress to do anything.
And Senator, did you know, since you reiterated your point several times, I'll reiterate mine. The question was not directed at those things that told the federal government what to do. It was simply a safeguard rail that got taken out.
Well, it's not a safeguard if you want a convention of states, because you're adding, that would be a new application.
So, well, you've answered my question, but we had to strip it down to what the initial proponents of this push years and years ago that approached me years ago.
Well, no, what already has passed, you need to be consistent with the language other states have already passed if you're going to be counted as the next application.
I understand that, Senator. So my next and last question for now would be that I would assume that following the standard process, since we amended the House version, that it would go back to them and could, for their vote, or either land in conference, correct?
Well, yes.
Okay.
Yes.
That's all for now, Senator.
Senator from McCormick, what purpose do you ask?
Mr. President, will the senator yield?
Yes.
For questions?
Question.
For questions. Senator yields for questions.
Senator from Charleston, thank you very much for taking the time and doing this in-depth study. I also came around. I was against the Convention of States, but I have also, after reading, I have become convinced that you're absolutely correct. That era we need to use, and it's unfortunate that we're even having to have this conversation, Senator, do you know? Why should we be doing this at all if the federal government would simply live within its means? I mean, here we are in the state of South Carolina, and we know how to live within our means. I'm sure you and your family and your budget, you know how to live within your means. The rest of us do. We all do. We all have to do it. It's a fundamental way of doing business. And yet our federal government, for reasons unknown, has decided to spend $30 trillion above and beyond what we've taken in. So my concern is that there are those people that oppose it, and I think we have to continue to work to educate them, make sure that they understand that this is our opportunity as states. Those powers that are left to the federal government are to the federal government, those to the states are left to the states, and those not to the states go to the people. But at the end of the day, it's the people, we the people who have accepted this government, have the right to call upon the government, do we not, to do right. And so if our legislatures, as the senator spoke of just a few moments ago, would do their job, yes, we could replace them. That's one option, and replace them and hope that the new senator or the new congressman would make sure that they got it through and they got a balanced budget or a physical restraint. We couldn't balance the budget right now if we wanted to. It would take a number of years for us to do that.
It'd be like rehab from a drug addiction. You have to wean yourself off of it is what would happen.
And wouldn't that take a few years to do that?
It'd take a few years, yes.
And we'd probably have to do something to tie it to our budget. It'd have to be tied to our gross national product in some way, shape, or form.
Yes. And so this language does not use the term balanced budget. It does use fiscal restraint. Balanced budget is a form of fiscal restraint, but it's not limited to the balanced budget.
Back when Ronald Reagan, in May 23rd, 1987, he said, "I'm one of those Americans who has always believed a constitutional amendment mandating that Congress balance the budget is the answer to what ails us." But he also went on later on and said that in the event they don't, then we have to turn to the states, and the states have to step up to the plate and take that responsibility and remind the federal government. You also agree, Senator, that oftentimes, because there may be sufficient 34 states, that all of a sudden the federal government will decide we had better do it, or the states may very well take that power from us.
Well, Senator, historically, that is what has happened, as we've discussed with the 17th Amendment in 1911. Before the last application, there was one application left that would have called the Convention of States, and when Congress saw that it was likely that there would be a Convention of States called, they exercised their power under Article 5 and called and amended the Constitution themselves to add the 17th Amendment. And that's and that would likely happen here too. Although, it would be to address these three issues of fiscal restraint, reining in federal power, and term limits for federal offices.
But then again, they may very well take those positions and fix them. If we get 33 and we're about to go to 34,
that's what I'm saying.
They may go ahead and take and do what they should have done without us having to go through this process.
That's the historical precedent. That's what they did with the 17th Amendment. That's correct.
And also, there were those who have said that, well, it's in the Constitution, but they really didn't mean it. But I think clearly, if you'll read Article 5, it clearly says that provided that no amendment which may be made prior to the year of 1808 shall in any manner affect the first and fourth clauses in the 9th section of the first article, and that no state without its consent shall be deprived of its equal suffrage in the Senate. My reason for pointing that out is in the body of Article 5, it clearly says that we expect you people, you states, in this balancing of power to use this from time to time in our federal government, even in this document. In other words, even in the Constitution itself, if they determined that some parts of it didn't work or it wasn't working in the best interest of the country, then they recognized that it was necessary that we come in and make possible changes or amendments, even at that point, if Congress didn't.
Yeah, Hamilton and Federalist 85, the words of this article, talking about Article 5, are preemptory. Nothing in particular is left to the discretion of that body, meaning Congress. We may safely rely on the disposition of the state legislatures to erect barriers against the encroachments of the national authority. And that was their view of why they put Article 5. And I'll tell you another interesting notion. We've had the debate about nullification in this chamber.
Right.
Before you were here, but those who've been here a while, y'all can remember the nullification of debates that we've had. And Madison actually weighed in on that during the nullification crisis of 1832. And Madison cited Article 5 as the means to push back against the federal government, not nullification.
It's interesting.
He cited Article 5 as something that is a legitimate constitutional way to push back against federal authority, not nullification of a federal law. Now, we also learned in that debate about the Prince decision and you can't commandeer state officials to do the bidding of the federal government. That's another limit on federal power. But Madison said, no. John C. Calhoun may come out and hit me with lightning, but no, nullification is not the way to do it. It's an Article 5 convention is what Madison said. That we put that in there when it's this bad where you feel like you need to nullify something.
And finally, as it relates to the protections of our delegates and not allowing our delegates to go out, you're comfortable with the language that we're trying to work to make sure there's limitation on our delegates. They won't become federal agents. They are state agents.
It's a
They are
convention
state-
of states, not
They
of
are,
the federal
state
government.
agents. They are South Carolina's agents, and we control our South Carolina agents. And if they violate the rules or regulations, then we can immediately recall them, and they have no power. It's void ab initio their authority.
That's
So
correct. And we have a bill that would accompany this that would establish an oath that they must give if they're going to be a delegate, and then a criminal penalties if they violate that oath.
you think that, and based upon all of your reading, are you comfortable that that will protect the state of South Carolina at that convention?
Well, I am comfortable. I wasn't comfortable initially, but like you, I've studied myself to be comfortable.
Thank you, Senator.
Thank you.
Thank you, Senator. Senator from Greenville, Senator Loftus, what purpose do you rise?
Senator Yield for questions.
Yes, sir.
Senator Yields for questions.
Thank you. Senator, thank you for taking point on this issue. You had mentioned several times that there's been more than 34 petitions or resolutions put forth already. Did I understand you correctly on that?
Collectively on
Collectively.
different subject matters,
Right.
on different subjects.
And I guess the simple question was, if that many has been presented, why hasn't the convention been formed? And I think I know the answer to that. But the question I do want to ask is, then how do you get to that point of being consistent with the issues that we will be dealing with?
Because there have not been 34 applications for the same issues, the same topics passed as of yet. There have been many more than 34 applications for diverse topics. The reason I make that point, and no convention of states has been called. The reason I make that point is that it is self-evident that those on both sides of this issue acknowledge that for a convention to be called, it must be called on a singular issue or even a specific set of issues, because no one has really argued that there is enough, that I know of anyway, maybe somebody out there has argued, but that we already have enough applications to call a convention, because we probably, if you add them all up, we have like close to 60 applications or something like that of 34 that are needed, but they're on different topics, different subject matters. So we've already embraced, what I'm saying is, in practice, historically, we've already embraced the notion that a convention is limited to the subject matter in an application. Otherwise, a convention would already have been called.
So where are we right now?
On this language, we would be
consistent-
number 19.
We'll
on
be
this
number
language.
19, so we still have a way to go on that. You talked about another bill that's coming up on the limitation of what our delegates can respond to or so forth. So but the convention can adopt just about, are they required to, if we find a consistency of 34 states in our petition, cannot the convention, can they add anything to that? Could they not?
I would say,
With the majority vote?
I would say no, they can't. Because again, I think historically, we've already embraced the notion that an application is limited to the subject matter in the application. Otherwise, there would have been a call, because we've already passed 34, number one. Number two, historically, and I encourage anyone who really is as much as a nerd as me to want to read stuff about the founding, but go read Pauline Meyer's book, Ratification, about the conventions in the states. And they stuck to the subject at hand and didn't deviate. And that was the practice. The framers understood, that generation, a convention to be something that is organized on an ad hoc basis for a particular purpose. It addresses that purpose, and then it disbands when it's done. And so I'm confident that would in fact happen. But if it doesn't happen, I don't think there's any way a so-called, quote, runaway convention would get the 75% ratification in the states, which is what's required that's your big safeguard against something crazy going on. I also believe a judge who was a textualist, who really looked at the language. What did the language mean? What did the language at the time that there were ratifications, ratifying conventions? What did a convention mean? And I think a judge who really looked at that history would draw a conclusion. If you deviate from the purpose of the call, then it's an illegitimate process that would be struck down as not in compliance with the Constitution.
Well, thank you, Senator. And I do some of the same reading. I just don't dig quite as deep as you do and have done. One question here on controlling our delegates. If they do not vote as we have intended them to vote, or required them to vote, then having to recall them, it comes back to this body or this General Assembly, and we take a vote on that?
Well, no, it would subject them to criminal penalties if they don't.
Okay, so it would go directly there rather than coming back to the House. Well, thank you for now, Senator.
Yes, sir. Thank you.
Senator from Richland, Senator Harpootlian, what purpose do you ask?
Would the senator yield to a question or two?
Yes.
Senator yields for questions.
So let me sort of follow up on the senator from Greenville's questions. So if someone went rogue as a delegate, their vote wouldn't be negated. What they do wouldn't be negated. They just perhaps go to jail for it. Is that correct?
They would go to jail if they cast a wrong vote, and whether that vote would be a terminal vote, in the sense a vote that actually passes a amendment, is questionable. I mean, it would probably be some decision, some effort to say we're going to go address this issue, which is beyond the scope of the calls, the applications that have been made. And at that point, at whatever point that you cast a vote inconsistent with the oath that you made, then you could be subject to a criminal penalty.
But that's a probably from you. That probably would happen.
Well,
I mean, let me ask you this.
I think that generally, as a procedural matter, that probably would happen.
Probably.
I suspect.
Probably.
Yeah.
And probably, if they did something like repeal the Second Amendment in this convention, that probably would not pass muster. Is that correct?
I don't think there's any question that wouldn't pass.
Well, I mean, who's going to decide that?
Well, at the end of the day, the 12 states, the 13 states, you can name them, you could tick them off,
Well, I
off
think
the top of your head,
but-
at least 13 states that would say not just no, but heck no, if you're going to try to mess with the Second Amendment.
Well, at this point in time, but maybe something changes in those states. Maybe the sentiment changes in those states. But I guess what I'm saying is, you deferred a moment ago and you said, well, a court would say this or a court would say that. I've looked at every possible way to look at a case that would come out of either the 1787 convention or any convention going forward. Would you agree with me? There's not a single court case interpreting Article 5 in this context?
Well, there's been no case or controversy for them to
Well,
interpret.
so the answer is yes. There's no case law out there. We don't know what. And by the way, just a little while ago, you were complaining about the aggressive federal court system that has created rights for the federal government. That's the same court system you're trusting to get this right? Is it?
Well, we have a much more conservative Supreme Court when it comes to sticking to the text and the historic meaning of the language and words than we have in the past.
Today
we do,
as
yes.
you would agree that ebbs and flows, right? The position, whether it's a liberal or conservative.
That does ebb and flow, yeah.
So if this were taken up in 3 or 4 years from now, people die on the Supreme Court. People get replaced on the Supreme Court. And so what you're betting is the current Supreme Court wouldn't do it. You can't tell us what a future Supreme Court would do. And I guess I keep coming back to this. Everything you've indicated would or would not happen. The senator from Greenville asked you about if they would be constrained. You say probably not. That probably wouldn't happen. But there's no absolutes here. You would agree with me.
Well, there's no absolutes in most areas of the law. And particularly, we've never had an Article 5 convention. We almost have, but we haven't.
It's ain't horseshoes, right? Almost doesn't count.
Well, that's true in almost all areas of the law. You don't know what a court's going to do. You don't know what an outcome of a future legislative body might do or a future convention might do. So I'm not making absolute statements because it'd be presumptive of me to make an absolute statement that I can guarantee this. That's why I'm saying probably.
So we're taking a risk. It's not absolute.
Sure, yes, and
Well, not everything we do.
pretty much everything you do in the law, you just don't know what a court's going to do with it down the road.
Typically, you have some sort of sense of what a court would do based on precedent. And you would agree with me, there's no precedent here.
I think there's a strong argument that the court would restrain a
Strong
convention.
argument. Well,
yes,
okay, I'm the court.
that's what we have in law. Is strong
I'm the court.
arguments.
I disagree with you, okay? I mean,
I know that, but you know that strong arguments is pretty much what you got when you go into
I
court of
lose a
law.
lot of strong arguments. And I've won a bunch, but I lose some too. And I lose more probably than I win because you don't know what's going on in that judge's mind. Judges are people and they have an experience that frames how they decide. So we don't know how the court would do. But so I'm looking for, just as you and I participate in drafting contracts, we draft them with belts and suspenders, and we don't put our clients in risk situations. We minimize, and to the extent we can, eliminate risk.
Well,
And wait a minute, the question is, does this proposal eliminate risk or minimize risk?
I think the framers minimize risk in Article 5 itself.
So
with a 2/3, 34 state application requirement and a 75%, 38 states ratification process, I think they put the belt and suspenders in place. And that's why they were supportive of it being a device, in their view, for the states to push back against federal overreach.
So in the three areas that we would send a group to this convention are on, one, is it eliminating the federal government's ability to go into debt?
No, it's fiscal restraint.
What's fiscal restraint?
It's fiscal restraint can be a lot of things. It can be a balanced budget amendment that we're going to balance the budget next year, or it could be we're going to go on a glide path to having the national debt being no more than X% of GDP, and it can be all types of proposals dealing with both monetary and fiscal policy. It can be, I mean, it's a broad proposal, but if it's something that results in fiscal largesse as opposed to putting us on a glide path towards fiscal restraint.
Well, I mean, could they restrict the expenditures on defense?
They could propose that, but is that going to get passed by 3/4 of states? I would say no.
We don't know, do we?
I would bet a lot of money, no.
Give me odds on that?
I'm not a gambler, but
Well, apparently you
I'm
are,
confident.
because you're gambling by the passage of this. You're not telling us with a certainty. You're telling us that you don't think 3/4 of states would agree to limit defense
I'm not
spending.
gambling. You're saying that James Madison and Alexander Hamilton and the framers of the Constitution were the gamblers.
No,
I'm just
not.
saying I see that they had faith that something crazy wouldn't happen because of the 3/4 ratification process, and they time and again said this is a power we give to the states, and if the federal government gets too powerful in the balance of powers under federalism, then here's a device you can use. And the framers are the ones that are gamblers, if any gamblers, not me.
Well, Senator Campson,
I'm just trying to follow what they
did you know that,
put in place.
that the convention didn't exactly do what you just said? That wasn't that reasoned, rational process. Have you read this book, Notes of the Debates in the Federal Convention of 1787 by James Madison?
I've said some of it, not all of it.
Okay, have you read the part about Article 5?
No, I've not read
Okay, would it
Article 5 in Madison.
Would it surprise you to know that a number of folks voted for Article 5, not for the altruistic reasons that you suggest? Let me cite to you what Mr. Gary of the state of Massachusetts said why he was voting for it. He said he had objections which determined him to withhold his name from the Constitution. The duration and eligibility of the Senate, the power of the House of Representatives, the power of Congress over the places of election, the unlimited power of Congress over their own compensations. Massachusetts has not had a due share of representation. 3 of 5 of the blacks are to be representatives, 3/5 of the blacks are to be representatives if they were freemen. Under the power over commerce, monopolies may be established. The vice president being made head of the Senate. He goes on, raise armies and money without limit, establish a tribunal without juries, which would be a star chambers to civil cases. Under such a view of the Constitution, the best that could be done, the best that could be conceived, was to provide for a second general convention. He voted for it. He supported it because he opposed what they did, these things, all these things. It wasn't, we want to rein in the power of the federal government. It was some of the most nefarious reasons I've ever heard. Now, you and I both know that people that said that people weak of stomach should not watch sausages or laws made.
Right.
And let me also tell you another one that's, I think, fascinating. Mr. Pinckney, who was from right here, South Carolina, he said nothing but confusion and contrariety could spring forward from the experiment of the second convention or a subsequent convention. The states will never agree in their plans, and the deputies to a second convention coming together under this discordant impressions of their constituents will never agree. Conventions are serious things and ought not to be repeated. He was not without objections as well as others to the plan. He objected to the contemptible weakness and dependence of the executive. He objected to the majority only of Congress over commerce, but apprehending the danger of a general confusion, ultimate decision by the sword, he should give the plan his support. So it was a balancing act, not this federal versus state, issues that he had, like commerce, huge issue. Colonel Mason from Virginia, he indicated he was upset about how a bare majority to pass navigation acts. He would not only enhance the freight, a consequence he did not so much regard, but would enable a few rich merchants in Philadelphia, New York, and Boston to monopolize the trade. He went on to say he would not support this Constitutional Convention, Article 5. A number of folks didn't vote. It was not a pretty picture, Article 5. It was not this Hamiltonian, and by the way, I looked, what did Alexander Hamilton say? You know what he said? Nothing, not a word, according to this journal. And this is the only.
He did say it. I was quoting from the Federalist Papers when I quoted where after the convention where he's articulating for the ratification.
Okay, but Federalist Papers are just him, expounding, bloviating on what he thought it ought to be. Not when he had a chance to do something about it.
Senator, if you look at the what you just described is simply what was the normal give and take in the entire Constitutional Convention.
Correct.
I mean, there was all kind of differing views that were a give and take, and finally, after they passed the end result, they said, "Okay, we're gonna move forward together on this." We do that in this body. We disagree on things, and we have extended debate, and we end up working out some type of compromise. And not everyone's happy with everything that happened, but it really produces probably the best outcome for the people of South Carolina.
You think a compromise is going to be worked out on this piece of legislation?
What I'm telling you, you're reading where the give and the take in the whole Constitutional Convention over the Article 5, that if you read about the convention, that applied to almost every part of it.
I read it.
That applies to almost every part of the Constitution.
Absolutely. My objection is you portray this as some sort of intellectual Hamilton's papers that, there was this decision that we ought to have this sharing of power, and this convention was created. This convention was created by a number of the folks insisted on it because they were totally dissatisfied with what they were signing on to in the original convention.
In the whole Constitution.
Correct.
That's
They were
right. That's
opposed
just
to
the
it.
nature. That was the nature of the constitutional debate.
But that's how Article 5 got created, by people saying, oh, we'll come back next year and fix it. So I just don't want there to be this misconception that somehow this was an immaculate conception of constitutional, moral. I didn't quite get the dog eat dog. No, it wasn't dog eat dog. What was it in the jungle? The fittest.
Survival of the fittest.
Survival of the fittest with this document. This had nothing to do with survival of the fittest. This had a lot to do with a number of different compromises, some of them based in the most basest of motives to create something where we could govern the country. And it's worked pretty damn good since 1787.
It has, even though there was a lot of discord during the debate, the give and take, not just on Article 5, on everything. But on every single bit of it. But once it was adopted and sent to the states, then there was pulling together and supporting the ratification of the best product that they could produce. And I would say that it has been proven to be a outstanding product over time, because what I talked about on survival of the fittest was I was talking about a culture's values and institutions are like its DNA. It promotes things that work and it weeds out things that don't work. And I know you're not a big hunter or outdoorsman, but I see that law at play, the survival of the fittest, all the time. And what it means is that you got to pay great deference to the conclusions that those have preceded you have drawn, because it is the repository of all the wisdom of the ages, pretty much. And we see that in the natural realm. We see it also in the human realm of human endeavors as well.
We're going to see what happens in Ukraine to see who the fittest is. Let me move to a different sort of question. As I understand it, we would be sending folks to a convention to deal with three issues: physical what? Restraint?
Fiscal restraint.
Whatever that means. Could mean anything to anybody. What was the second one?
Well, it can't mean fiscal large S. It means mechanisms to term limits for federal office.
Okay, so you're supporting this. Are you supporting, do you think there ought to be term limits?
For federal officials, yes.
Not state officials?
No.
No. Why?
Well, I've done a term limit when I was in the House. I committed to serve 3 terms, and I did, and I quit.
Right, but those are self-imposed?
Yes.
Okay, I'm talking about.
But this is why I don't think, Senator, for the Senate, for the state legislature, I have a very good reason.
What is it?
That is that we do this on a part-time basis. We all, unless you're retired, we all have jobs in the real world where we're having to support our families, run a business, get business licenses, get permits from state and local agencies. We have to live and work under the laws that we pass. It is citizen statesmanship at its best, because we do this as a part-time job and we're active participants in the real economy. When you go to, and we serve for a few months, 3 days a week, and then we go home and we keep running our business. You practice law, many lawyers in here, many business people in here, and it keeps you get a lot better lawmaking if the laws are made by someone who lives and works under the laws they pass. What Congress is, their rules require you to sell any business interests you have, and you become a full-time politician, and you've made an irrevocable career path decision when you do that. If I sell my business, if you sold your law practice to serve in Congress because the rules under the House and Senate ethics committees make you do this, what you've done is you've made an irrevocable career path decision. You're going to be a politician in Washington, and by golly, you're going to stay a politician in Washington because you don't have anything else to fall back on. You just sold your business. You just shut down your law practice. That does not happen here. And so you don't have citizen legislators. You have people in Congress who they made an irrevocable career path decision, and by golly, they're going to do whatever it takes to stay there For us,
We're not going to do whatever it takes to stay here?
for us, we are all,
We're not
Senator-
going to take whatever it takes to stay
no,
here.
we're not, Senator.
Wow, that's,
Well,
Maybe you need a roll
I don't
call
know
vote on
about
that.
you, but for me, I'm on the bubble. I mean, one moment I'm saying, why am I doing this? It's not worth sacrifice. And the next moment, I did something that made South Carolina a much better place. And I'm saying, wow, my life is making a difference. And that's what matters. And also staying in the private sector, that's what matters. And so if you're not on the bubble, why am I doing this? This is crazy. It's not worth the effort. Versus, man, I really made a difference today or in this bill or in this issue. And so my life, it gives my life South Carolina's a better place because I served.
so the
That's
Congress.
the only thing that keeps me going. I mean,
Congressman,
otherwise it's not, we are not part of the professional political class like we are in D.C.
Really? You can
Yes.
stand there with a
Yes.
straight face and
Yes,
say we're not
really,
part of
Senator. I run businesses. I practice law. If you think that I'm part of the professional political class, you are dead wrong.
My
I
question, what
lose
is a
money by
professional-
doing this.
What is a professional political class?
People who are professional politicians and they made that their career path decision and they're going to do whatever it
What?
takes to stay there.
Like
That's
Nikki
a
Haley, maybe?
congressman.
Nikki Haley, is she a professional politician?
No, she's in the private sector, isn't she? She's in the private sector, isn't she?
Look,
Senator, if you don't understand you've been here a while. I'm really we are very different than Congress.
am I disappointing you? Am I disappointing you?
Well, I was going to say that, but I didn't want to.
I don't want to disappoint you.
I was going to say that. Unanimous consent. We're disappointed in the senator from Richmond.
Let me just ask.
No, but I really hope that you see that the state legislature is still a citizen legislative body. It is. I mean, we work, we run businesses, we employ people, we serve people under the laws we
Well,
pass.
how does term limits change that? All it means is they're going to be professional politicians for 6 years and then have to leave.
Well,
they're
you know
not
what?
citizen.
You know what I think? I think you'd have to change for term limits. You'd have to change that rule probably in Congress. That's what I think. It's an ethics committee rule. If you're Nancy Pelosi and you own, you married into the Heinz fortune and you have publicly traded stock, you can put that in a blind trust and you keep going. If you're a small business guy, you've got to sell your business interests. It's not liquid because it's not publicly traded. So you sell it. I've had members of Congress who ran and won and called me and said, I had to sell my business on a fire sale? I said, yeah, I knew you would have to do that.
So
Why didn't you tell me that?
But
Well,
they're
you
making
never
a
asked.
sacrifice. They've sacrificed.
So that's so no one's going to do that and serve for only 6 years. They're not going to sell the business or practice they spent their life building to serve for 6 years and then have nothing to go back to. So that would have to change.
But
probably.
why wouldn't we do that? Serve for 6 years or 10 years or whatever it is and go back to these thriving businesses we've struggled to keep alive. I tell you, that is a struggle for those of us who practice law every day.
It's a struggle.
And any business person has to
Yes,
struggle
it's a
with
struggle.
that. So we're making sacrifices. They're making sacrifices. So why don't we limit us too?
Well, I've done it, Senator, but I realized that it was really not something that even was necessarily, I did it, I honored it, but I realized it was something that really didn't squarely apply to the state legislature the way it did with Congress, because we are all part-time running businesses in the real world. We're not full-time politicians who, once you sell your business or shut down your practice, and you get elected to Congress, by golly, you can do whatever it takes to stay there. I think we're much better served by people who one moment say, why am I doing this? It's so frustrating and it's costing me a lot back home and flips over to, man, this is really rewarding. I just made a difference in the world. South Carolina's gonna be a different place because I served. And all of us have had that experience. I'm not saying that's limited to me. I think all of us have that experience. Except you apparently, Senator. I'm not gonna speak for
I'm just
you.
sitting here. What difference have I made? Anybody? Anybody. Thank you, Senator.
Senator from, after we calm down for a minute, the senator from Williamsburg, what purpose do you have?
Thanks, Mr. President. See whether the senator from Charleston would yield for a few more questions.
Can I
Well, the sen-
tell
well,
what
the
difference the
senator yield
senator has
for
made
questions.
when he can't ask me questions? But you want me to do that?
I'd love to hear a response on that one.
Let's not. So,
What a difference you made in my life.
Senator from
Rank-
Charleston.
Senator from Horry wants me to sing that song, but I can't sing.
Senator
Thank you,
from
Mr. President.
Williamsburg.
Thank you, Senator from Charleston.
Sir.
So let me begin by saying that, when I question doctors or other professionals from time to time, Senator, did you know that one of the things that I do is I don't really talk to them about that which they know so much more about. I tend to deal with peripheral issues. And Senator, did you know that that's kind of how I feel when I'm getting ready to question you about constitutional matters? Did you know that?
I did not know that, Senator, but I take that as a compliment. But I didn't know that because you are quite a scholar yourself. So.
Senator, I don't think that they could have found a better person to take the lead on the legislation. But also, did you know that I appreciated your position more in the beginning when you were against than I do now that you're for?
So you think I studied myself in the wrong direction?
I really
What
do,
you're
Senator.
saying?
I honestly do. I honestly do. But on a serious note, one of the points that you made in one of the exchanges, and there have been so many good exchanges, I don't recall specifically which one, but you all talked in terms of the Convention of States essentially being an experiment, Senator. And I know that the democracy that we live in has been classified by many scholars as being an experiment. Do you agree with me on that?
It's been referred to as an experiment in self-governance.
Yes, sir.
Yes.
A lot rides on the success of the experiment. Do you agree with me on that?
Oh, yeah.
I'm talking as it relates to America and this experiment in democracy. A lot rides.
Yes, it does. Yes.
Senator, do you know that I liken the idea of the experiment of the Convention of States the same way? Did you know that?
No, I didn't.
Senator, one of the exchanges dealt with the issue of what happens when a delegate is chosen and goes to the convention. And I heard a part of the conversation which suggested that the vote that's cast by the delegate would likely be void ab initio. Senator, do you know that I don't agree with that? And I'm curious as to whether or not your position is that if an individual goes and votes in a manner that some, and I'm not sure who the some would be, that classifies the vote as being outside of the bounds of the directives, that vote would be void ab initio. Do you really believe that, Senator?
No, I don't think I meant to convey that.
And you did not respond to it, and that's why I wanted to address it, because, Senator, do you know that I believe that vote counts?
Well, the vote, two things, the way a vote like that would be handled. Number one, if we pass the bill that's going to follow this, then it would be a criminal penalties if a delegate voted in a way that is inconsistent with the application for the Convention of States. Like if you show up and you try to repeal the Second Amendment, as we had a discussion earlier today, that is not in this application. It's not within the subject matter of those three items. And so you would be subject to a criminal penalty for that. That's number one. Number two, a court, and it would ultimately be the Supreme Court, looking at that vote, if it ends up, if we pass this, you end up appealing the Second Amendment, that's what comes back. I believe that a that the court would look at that and really say that that is unconstitutional because it was not in accordance with the applications that are made for the Convention of States that ask for fiscal restraint, federal term limits, restraint on federal power, and yet the convention comes back with repealing the Second Amendment. So that's where I think it would be challenged in federal court, and I think the court would, I mean, you don't know what a court's going to do. I mean, no certainty, but I think there's a good argument that the court would strike that down as unconstitutional because because it was inconsistent with the applications that were made for the Convention of States.
And
or the 34 applications that were made.
well, let's talk about let's talk about applications and rules. What's your understanding, Senator, about what parliamentary rules would be in effect at the Convention of States?
Well, the convention would determine their own rules.
So you don't believe that, what is that, Masons, whatever?
Well, I mean, there's a good argument to use Masons. The House uses Masons. We use Jeffersons as for our backup rules, but.
And Masons actually has a rule that says that you can change your rules, right?
That you can change Masons' rules?
No, that if there are rules, if you assume hypothetically that there are rules going into the convention, right? Assume South Carolina has decided that this is how we want this to be.
You'd have to agree on rules. The states would have to agree on the rules, just like we have to in this chamber.
Yeah, but if you agree on rules and you go to a convention and the rules that govern the convention say that you can change the rules, then the rules become subject to change.
Yeah.
Right?
Yes.
And such is the case with Masons, right?
Well, sure. Every set of rules has a ability to change the rules because otherwise they become unworkable because you don't get them all right in the first go round.
And so, Senator, did you know that therein lies some of my heartburn? All of a sudden, what was fixed by the rules has changed. And Senator, do you know that when one thing changes, sometimes guess what else happens? Something else changes. And Senator, I don't believe, and I've listened, and I appreciate the conversations that I've had with a number of the proponents of the Convention of States. One of the things that I did not do is I didn't limit audiences. And so when any of them wanted to come and have a conversation, I held the conversations, trying to listen and trying to be informed. But do you know that I'm absolutely satisfied that the exchange that you and I just had is real? And that is that rules can simply be changed. And there's nothing this body can do, I don't believe, to govern whether or not the rules at a convention changes.
Well, Senator, if a convention is called for a particular purpose, that's not a function of the rules. That's a function of the applications that the states have submitted. And the rules of the convention are the internal rules that govern the procedure, like we have the Senate rules and the House has the House rules. But the purpose of the convention itself is a function of 34 applications that are consistent in the subject matter for which the convention is called. And that's the rule that I think will not change. And if it does, I think that's where a court would step in, because the applications that are called for in the Constitution, 34 of them were passed by the states to have a convention for the particular purpose set forth in the call and the applications. That's where the court would step in my view.
And Senator, I have a strong suspicion that that's probably one of those issues that you and I, like many scholars, would continue to respectfully disagree with each other on. And I've read, I don't consider myself as learned as many who studied probably substantially more, but I've seen a number of scholars differ on a lot of the subject matters that we're talking about in terms of how things would really go.
Right.
And that's troubling to me because those are people who are learned. I mean, who are in the know, and they just simply don't agree. And I've listened, shall I say, I've read both arguments, and quite frankly, Senator, both arguments make sense. I just don't know, and so that unknown gives me
Well,
significant.
I had a similar position as you originally, and really the safeguard to me is the 3/4 ratification. I mean, to get 38 states to agree on some crazy product of a convention of states is extremely unlikely. That's number one. Number two, the framers, like I say, had it in there as a balancing to rebalance the power between the federal and state government. And, I mean, you take the national debt, for example, I mean, we're at 125, 130% of GDP, and higher than we were in World War II. Just in 2000, we were at 55%.
Senator,
We've more than doubled, and are we kind of in desperate territory or difficult territory when it comes to that? We are. I mean, $233,000 per family. How many families in your district could bear the load of a $233,000 debt? That's their share of the national debt.
Senator, did you know that as a young married man, one of the more proud moments that I had dealing with a president is when President Clinton made his pledge about the balanced budget and then attacking the national debt. And one of the vivid memories that I have is when he got that, what I call the old-fashioned boards, and took his left hand and circled it. And I don't know why people put the strike in the middle of the zeros. I've never exactly figured that, but that's exactly the way you did it.
Differentiate between a zero and an O.
Oh, yeah, thank you for you and the senator from Clarendon. I appreciate that. I've always wondered that. So you knew that tomorrow, of course. But I guess I'll tell this one too. And Senator, what else is interesting about that moment in my life was early in marriage, just beginning to earn a reasonable salary, and had eased over into that financial realm. And so had a wonderful conversation with my wife about how we felt about it, because, there's a sort of reconciliation for me between giving cheerfully and just giving grudgingly. And quite frankly, there was a part of me that wanted to give cheerfully. And so it was a wonderful conversation between me and my wife, and we felt good about it, and we gave cheerfully. But anyway, Senator, that sort of segues us in to what I believe is a broad instruction. Senator, I think that fiscal restraint is a broad subject. And when I look at the idea of instructions that's given, and whether or not a person who goes and wants to do the right thing can get confused and be prosecuted for doing what he or she thinks is the right thing, but whomever the judge is that decides whether or not their vote is one of fiscal constraint disagrees. Do you know that troubles me as well, Senator?
Well, I can understand that.
Are you troubled by it also, Senator?
No, I think it's pretty clear when you're trying to promote a policy of fiscal restraint versus fiscal largesse, I guess, is the antithesis of fiscal restraint. And that's pretty clear. And and I think you'd get communication from the state leaders, hey, this is not what we had in mind when you signed the oath about you're going to pursue fiscal restraint when they're trying to expand the federal budget dramatically.
And Senator, do you know that that's also distressing to me?
Yeah.
The fact that there would be guidance given from some, and I don't know who would appoint those individuals as being the authority over the individual who is actually casting the vote, and who directs the communication and the level of communication and all of that thing. That's another one of the things, Senator, that troubles me about the legislation and the Convention of States. And there's a question in there somewhere, because...
Yes, I knew that troubled you, Senator. Yes, I knew that.
And I'm curious though, Senator, and I know you've studied this and have given much thought to it, but I'm curious as to your take on it, because as far as I'm concerned, I mean, the likelihood is that I'll vote against the measure when it ultimately comes up, but I'm curious as to my colleagues and their thought processes relating to some of it. And so I'm curious about what your vision or your view is of that issue.
Well, like I've said numerous times today, that that is the 3/4 vote threshold that I think if you come back with something that's just really out of line, it only takes 13 states to say no. And I think that's a real safeguard. And when it comes to the restraint on who's a delegate and what they do, we would have a hand in picking a delegate. We would the criminal penalties associated with fiscal restraint, having a broader measure. I mean, I think fiscal restraint certainly is not fiscal large S, and so fiscal restraint is about putting us on a more sustainable financial footing in the nation, as opposed to 130% of GDP.
Opportunity to cut education.
As
Education would be something that would be on the table in terms of fiscal restraint. Would you agree or disagree?
well, of course, a lot of that's state funding,
Only talking from the federal.
federal.
Yes, sir, I agree.
Yeah.
Only talking from the federal point of view. Education would be on the table.
Well, anything that you spend money on could be on the
Social Security
table.
would be on the table.
Yes.
What we spend on elections would be on the table.
Anything the federal government spends.
Medicaid, Medicare, serious stuff. No question that the citizens of South Carolina and the citizens of the United States of America would be impacted by those decisions. And Senator, have you given any thought to what the crowd at the Convention of States is going to be like? The people that have a vested interest in the United States of America, when they learn that their lives can change as a result of the decisions that are made in this hall, what will the people reaction be?
The people, the delegates, or the people?
People. I'm talking about the regular citizen who has no voice. They didn't elect those delegates. Those delegates are not accountable to them. What will the people do? What would that crowd be like? There are a lot of people who love America. There are a lot of people who understand the benefits of being a citizen of America. So my question is, have you given any thought to what the crowd is going to be like? What the mood of the crowd is going to be like?
Population of the nation, you mean? The
So,
citizens
Senator,
of the nation?
So, Senator, let's just think about some of the issues. Abortion, for instance. When the Supreme Court is hearing about abortion, or some of the election laws, or civil rights legislation in the old days, the huge crowds that come to Washington and want to be a part, whatever way they view their role ought to be, but don't believe that they can afford to sit silent on the sidelines while something is happening. Have you given any thought to what that mood, what that climate, what that crowd is going to be like?
Some, yes.
Senator, do you know that that worries me? Some have said that our democracy, as we speak right here, right now, is as fragile as she has ever been since the Constitution was enacted. Have you heard that, Senator? You have any thoughts on that?
Well, I think that there's some truth to that. I think that your political situation is really a function of what's going on in the culture. It's really a cultural issue that is manifesting itself in the political realm, is what we're seeing.
And Senator, do you know that I believe you're exactly right? There are some things on top of that, though, but I think you're exactly right. I think a lot of the undercurrent is there, and there have been things that have piled on top of it, and I think it's lent itself to the fragile state that our democracy finds itself in. I wanted to, let's shift gears for a second. Get the language right.
You didn't practice this, did you, Senator?
No, no, sir. But I wanted to talk a little bit about the federal power aspect of it, and I wanted to borrow the language, if I can find it real quick, when it talks about, well, Marlon will find it for me. What does it say? For the purpose of restraining these, no, that's not what I'm looking for. But the second tier, if you will, Senator, dealing with federal powers. Help me with that. What does it say about federal powers? So one is
to rein in federal power.
Rein in federal powers. Senator, do you agree with me that that's broad?
Yes, yes.
Very broad.
Yes.
And federal powers can be so many things, right?
Yes, it could.
But the instruction to the delegate is to rein in federal powers. That's his or her marching orders. I don't know how, you can help me with this, Senator, please, but I don't know how we educate, and I know there's a plan. I'm just probably not in the room when it's being discussed, but the plan to educate the delegate on reining in federal powers. What does it mean? What is the delegate advocating for?
Well, it's really going to be a part of the give and take of a convention process, but, an example of federal power that needs to be reined in is the way they deal with regulations. Earlier today, we passed some regulations out of my subcommittee. We didn't pass them. We recommitted it to the
yes, sir, and it'll time out
forestry.
And
they've been on the calendar for 2 weeks. Anyone to look at them, have issues, they can go talk to the agency. The agency typically often changes or modifies, withdraws and modifies if there's any legitimate concerns. And as we all know, that often happens. And that's a process that really restrains executive branch power.
yes, sir.
Fish, game, and forestry, it's important for hunters and fishermen, but you have DHEC regs, you have all kind of regs, all over state government, and the federal government really doesn't engage in that process. I mean, Congress just cedes power to the regulatory authority to the administrative branch and the executive branch to the agencies, and they just crank out regulations without any kind of oversight from Congress. And so, to me, that's one of the biggest examples of really federal power getting out of reach, and we don't do that in South Carolina, and that's one reason why we have less of that kind of overreach. I mean, that's just one little small example, but that's an example of reining in federal power, because Congress largely has ceded legislative power really to the regulatory state at the federal level.
All right, so let's talk a controversial issue just for a second. Let's talk global warming,
Yeah.
right? There will be efforts to change how we do things, because there are a lot of scientists that believe that we can reverse global warming. And obviously, Senator, that's for those of us who believe that global warming is happening and are buying into the science that suggests what is giving rise to the global warming. So there will be regulations when the Democrats are in power, right, that would promote that. And if you disagree with me, Senator, you can help me. And then when the Republicans are in power, there'd be fewer regulations more than likely on that issue. Do we agree with that?
Well, that would be likely.
Yes, sir. And so I guess my point then would be, would that be an example of how the Convention of States ought to operate, such that it says to the federal government, whoever's there, we don't want any regulations dealing with global warming?
No, I don't believe. I mean, what I just suggested was Congress reestablishing its legislative oversight in the regulatory process. We never surrendered that. We never gave that up. And it's a very important check on the executive branch power, on the administrative state. So, I mean, a prudent delegate, it's not about this particular issue or that particular, it's really about processes and structure of government and putting back into place. Really, it's like the framers put it, like James Madison said, ambition must counteract ambition. He's talking about each branch and their political ambition for control counterbalance ambition in another branch. And when Congress just cedes to the regulatory state regulatory power authority without their oversight, they're really ceding a lot of power to the regulatory state. And so take back your regulatory oversight, because what you're doing is the political ambition of the legislative branch would be a check on the political ambition of the executive branch, and vice versa. But because that process has been abandoned basically at the federal level by Congress, it's something that, as a process, it's not addressing any particular issue, but as a process, that would rein in some federal overreach, because it would create a check and balance among the three different branches at the federal level, checking and balancing the other branches. And that, in my view, that's the type of thing that you would be putting in place. And I think that's the type of thing the framers really put in place. I mean, that's the kind of debate they had. Now, they disagreed, like the senator from Richmond said, on things, and some things that Madison fought against at the convention, he ended up advocating for when he's writing the Federalist Papers, because he's got a different role there. He's advocating people. He did the best he could. He didn't win every battle in the convention, but once it's been passed, then he's advocating for the passage of the Constitution. And so he's become an advocate for things that in the past he just didn't get 100% of what he wanted, but maybe he got 40%. And
Sounds like that old dirty word they call compromise.
Yes, it does.
Sounds like that
Yes,
probably
yes.
took place. Senator, you know that what you just shared is well thought out. But do you know that the delegate may not have an appreciation for all that you've experienced that has led you to that conclusion? Do you know that the likelihood, in my view, but I don't know who y'all have in mind, I'm sure y'all might have given some
We were
thought
thinking about you, Senator, until you started speaking against this.
But I guess my
You can
point,
recover, though. You still have a chance.
that's right. So my point, as long as there's breath, there's hope, right? But my point would be the idea of, and I think it's still up in the air as to how many delegates a state can have. I mean, I think.
Well, historically, on the Constitutional Convention, it was 7, and Pennsylvania had 8, but everyone still had the same. For some reason, I forget the reason, but they were allowed the 8, but they still got the same weighted vote.
And do you know that some scholars disagree on how that plays out at a convention of states? There's scholarly disagreement on whether or not states are free to have as many delegates as they want to come. And there are some that would argue that it's not one state, one vote.
Well, it is a convention of states, not of delegates. So, and the states, you could have 100 delegates, but you can still get your one vote. I mean, that's the historic precedent, and it is a convention of the states, not the delegates that states appoint.
Yeah.
Like we can't appoint 7 delegates and then another state appoint 1,000, and they get 1,000 more weighted vote than us, or it's a convention of states.
Yeah, I found it interesting that there was scholarly disagreement on it.
Yeah.
I kind of agree with you. I think it ought to be simplistic enough, and that's the way it ought to be.
And you're even diffusing the power with 7 delegates and 1 vote, because there's give and take among the states.
But
The states have to. We have to agree on something before we take this position.
But you've brought more brain power.
Yes.
You've brought more people that can talk to more people and perhaps persuade more people to their viewpoint.
Correct.
And so, but it concerns me, Senator, that's not an issue that's already ironed out. And that's why when we are willing to risk this experiment in democracy for an experiment in a convention, there are just too many of those kinds of unknowns where I don't know how, and this could just be Ronnie Sabb, but I don't know how, if the general public ever paid attention to what we're talking about, how they could have confidence that the country that they are living in doesn't change as a result of Convention of States. I just don't know where the confidence comes from, because there are so many unknown questions, and obviously you're scholarly, and I'm not just saying that for the sake of it, but I mean, you've studied these issues, you know it, and still there are a lot of things that we still simply don't know, Senator. And I'm gonna ask a few more questions if you don't mind, please, and then I'll be finished. I was struck by the conversation that you and the senator from Orangeburg was having. And the senator from Orangeburg, who's not a lawyer, my sweet mate, maybe that's some lawyer.
Some cases, though, wasn't he?
Yeah, that's some lawyer in me, must be rubbing off on him or something like that, I don't know. But he quoted this language, and I found it interesting, where the United States Supreme Court in Bush versus Palm Beach held that when state officials derive their power from the United States Constitution, that federal laws can restrain the actions of those state officials. That's powerful language That's a powerful holding and dicta to be used in other situations and circumstances. And so, Senator, as I was listening to you and the senator from Orangeburg talk, I said to myself, wait a minute, what role does Congress play in this whole thing?
Well, Senator, I think, I mean, I read parts of that case a long time ago.
You and I both.
But I haven't read it recently. But I suspect, like I said when the senator from Orangeburg brought this up, I suspect what you're seeing in that dicta in that case is an application of the federal elections clause, which gives to the states power over the time, place, and manner of federal elections, except in the manner with Congress preserving the ability to legislate into that area. And so, and Congress has legislated, not a lot, but they have legislated into election law. They've done it through the Help America Vote Act. They've done it with some of the civil rights acts. They've done it in various ways. The Military Voters Act, where you have to get a ballot within 45 days out, the Military and Overseas Voters Act. And so I think they're probably they're referring in that section of that case, referring to those federal laws that the local officials are enforcing, and the federal government has power over the way they enforce it, but not power over the way they enforce Florida's state election laws that aren't backed up by any kind of federal legislation. That's, I suspect, they're just acknowledging the reality of the way that authority over elections is divided between the state and the federal government, with the federal government having little but meaningful, very meaningful, but a smaller amount of power.
So Senator, then
I suspect, but
no, I get it. So, but to tie it in greater ways. So then a part of your conclusion based on your suspicion.
yeah, and I haven't read the case in years, but
Yeah. And
I remember the hanging chads, though, Senator. I do remember that.
we all do. We all do, I think. But is it your thinking that because of the last line that you mentioned in the election clause, because that last line is not in Article 5, that it's probably a different kind of an analysis where the federal
I'm not really not saying that because I think that Article 5, a convention of states under Article 5, is a state initiated. It's authorized by the Constitution, but there is no prescription of what the states are going to do. When it comes to federal election law, there are prescriptions in that law of what the state officials that are running the polls have to do. To the extent the federal government has legislated in that area, to the extent they haven't, the state law applies. And so there is not that prescription here. So, I mean, it's just, it authorizes this, but it doesn't prescribe how these delegates have to vote or what they have to do. So I think there's a difference that's going to keep the federal government from kind of commandeering the delegates and making them do certain things, because there is no federal prescription on how they will behave. But if you look at the Voting Rights Act, or you look at the Help America Vote Act, or the Overseas and Military Voters Act, there are prescriptions that the state and county election officials must follow to be in compliance with federal law.
So, Senator, do you know when I was talking about that last line, I was really talking about the prescription. Okay. And so I thought that I was following you correctly. It's that prescription that leads you to the conclusion that it's just different as relates. Yeah. Yes, so yeah, I followed you on that. Something else is gonna pop in my head as soon as I sit down, but I appreciate, let me just check one more quick thing. So I believe that's all I have. Thank you so much.
Senator from Richmond, what purpose do you raise?
Before he sits down,
Senator from Charleston is giving,
give up the floor.
he's given up the floor.
Mr. President, unanimous consent at the,
State your,
at the next available date, move that the Senate adjourn in the memories of Jeffrey B. Smokes, whose son Tucker works here at the State House.
without objection, so ordered.
Mr. President,
Thank you.
wish to be heard.
We need to publish the committee amendment.
Okay.
The reading clerk will read.
The Judiciary Committee proposes the following amendment, amends a joint resolution. It strikes all after the title and inserts the following, whereas.
Senator from Richland. Still wish to be recognized.
I'll be glad to read it if you want the amendment read in its entirety.
The whole thing? Senator from Richland is recognized on the committee amendment.
Mr. President, members of the Senate, as I sit back and I can appreciate the will of the Judiciary Committee members, and I saw them equally continue to participate in this discussion. And as one who was no longer on Judiciary, having served for many, many years on the Pentagon and Finance. And so I look at, from the financial point of view, where we are in this country and what is the real driving force behind creating a convention and why we want to make most of the change. Is it really policy, or is it decisions we call policy based upon where we are and have been in this country? And so I began to kind of take the debt apart. And right now today, as the debt clock continues to move, we're in the ballpark of $30+ trillion and growing. And as I listened to the senator from Charleston who shared with you the amount of debt, and I think he said each citizen, I do not want to quote him wrong, he said it was somewhere around $231,000 per person. Let me correct that. And again, not to create any confrontation, but just to get the facts straight. The 241,000, and that's for tax-paying citizen. For each citizen is 91,000. Just want to get that straight. And that's a big difference when you look at South Carolina as a very good example. And we just came out of finance where we saw 43% of South Carolina citizens who are participating in the tax-paying process but don't really pay taxes. And so I don't know what those true numbers actually looks like when you look at the 331 million U.S. citizens we actually have, and what that equates to as it relates to those who are actually tax-paying citizens versus when you divide it equal among citizens. Someone kind of get that straight. I also want to remind us as we move forward to look at policies, especially tax policy, I want to remind you that we have come out of several wars over the last 20 years. And going into wars and coming out of wars costs a lot of money. We finally left Afghanistan, and we've been in Iraq, Pakistan, and so many other wars in the last 20 years to the tune of $8 trillion. And so when the previous president took office outside of tax credits and tax breaks, and no matter what that president policy may have been, I'm hoping it was for the growth and benefit of all Americans in terms of trying to create wealth to the point that you can you're wealthy enough to send your kids to school, you participate in the American dream, and you create some funds for the point when you retire and go home. And so finally we made a decision to bring them home. But you still can't bring home the $8 trillion that you spent over that time period. And so we look at 2020, where we were in debt service before the last 2 years. But before, you got to go roll back 4 more years to see where we were. 19.9 trillion, one president go out, leaving $26.9 trillion. Some said an increase of 6.7. Others says the numbers may be slightly higher at $7.8 trillion increase. But keep in mind, war going on, create some tax bills that still cost the American citizen additional money. As we look at the federal government, and also including the payments in terms of where we are, and when we sell those bonds to be able to pay the tax bill, a lot of that money is left in the United States. I heard so many times people talk about Japan and China, how much debt service. The last time I checked was about $6 trillion. That was not here in the United States. And so that investment was back in the United States, going back into the pockets of banks, insurance companies, and others who, in fact, would make that investment. We move on, and 2020 comes about. Change in government, change in policy, and there's a pandemic. Pandemic costs us anywhere from $4.6 trillion to about $6 trillion. And what was that all about? We learned some things as it relates to this economy over the last 4 or 5 different times that the economy has gotten itself upside down. Inflation became so high, and we move into a recession. And so the goal was to make sure, in looking at interest rates, and also in looking at keeping the jobs moving, and also providing stimulus checks and paying the unemployment bill and making things work, we spent some $6 trillion. And also COVID relief. Also, not one person has paid unless you just decided to pay to get your COVID shot. The American people and the American public participated. And so I'm really concerned about a couple of things as we try to maintain an economy that works, an economy that doesn't get itself behind. And so we looked at a couple of issues, or shall I say the Congress looked at a couple of issues, the same group, who all of a sudden this Congress doesn't work, but still yet we've not gone underwater. We've not drowned. And they looked at some of the issues. What will it take to get the economy back moving, and how things could continue to move after the pandemic? And so they came up with the child care tax credit, which I thought it was great. And we struggled in this state and across this country and even Congress as moving the minimum wage bill. Well, guess what? The general public moved it for you. It simply says we are not going to work anymore. We understand there is a better life. And if you want us to work, you're going to have to pay for those services. And so if you've been to McDonald's and Hardee's and Burger Kings and your fast foods that you like, it's not fast anymore. The workers are not going to work for minimum wages anymore. And so what that has done is created within itself an economic change as it relates to small business. And we depend on those small businesses across this country. And that's why McDonald's said, today, we're closing up all the restaurants in Russia, some 800 restaurants in Russia. And so those folk who would work for the minimum dollars in those stores, they're going to feel an impact, because they still got to feed those people at home. And those people are going to still be asking the question, why are we at a war fighting other Russians in other parts that used to be part of the Soviet Union? And so those are some real questions to ask. And so when I take a real look at this $30 trillion, I'm looking at 14.5, roughly $15 trillion that have actually been invested back in maintaining good health, getting people ready to go back to work, keeping our kids safe at schools, keeping us healthy. And if you look at the amount of U.S. citizens and folk across this country who died this world, I think we had 6 million people because of COVID, and it's still not over. And so I think you need to think twice when you're right in the middle of what's going on, not only in the United States, but across this world, before we decide that we now want to go in and tell Congress how to run their business. And we care not for folk to come in to tell us how we're going to run our business. And I know some have not been satisfied with the stimulus checks that have gone out. But guess what? We get ready to send some stimulus checks out ourselves. We're going to debate that within the next couple of days. I think $1 billion worth of return stimulus money back to the taxpayer. Back to the taxpayer. If you participate in that tax process, whether you paid income tax or you bought food items and you paid other forms of taxes that end up in that general fund because of the surplus, we're going to be looking at sales taxes and others, vehicles and everything else, and how we return some of that money back to you as a stimulus. The House said $600 million. We said $1 billion. And so if you look at how we've actually operated in South Carolina, and I can't speak for other parts of the country and what they do in their Senate and their House and their Congress, I can only speak for what we do this. A lot of our own behavior outside of just radical fighting and dog-eat-dog kind of Washington behavior, at least we try to operate in a very civilized manner. But some of the same things we do in giving rebate backs and creating tax credits and trying to keep the state moving, we've been able to do it. And so if you really take where you are, and the president is trying not to go into another war, because when you get into those kinds of war, we thought Afghanistan was going to be quick and out and stay 20 years. And so if you get in a war, European war, and helping NATO and get NATO involved in this process, folk you in for a long, long haul. I went a little bit further because I went all the way back to the early 50s and where we were and what percentage of debt service we had. And I looked at what we spent in the Vietnam War. I think it was $330 million, $130 million. And looking at the value of that money, the value of that money was still $1 trillion in America, in dollars as it relates to the dollars that we would actually be paying now. And so you also have to look at where we are, inflation rates, whole lot of other different things. So we're looking at, in 10 years ago, 58%, now 125% in terms of debt service. But you also have to look at debt revenue collection when you start looking at debt service. And folks, we have not done a good job now in policy in creating so that there is a break-even point between what you're spending annually and what you're actually taking in. So there are going to be some adjustments, but we've got to get through the difficult times. And the pandemic has cost this country a lot of money. We've been fortunate in this state, and we have to smile because as we talk about in this state, wanting to create a convention and wanting us to have oversight over the federal government, which has put us in the greatest positions we've been in the 30 years that I've been here. And now we're talking about this state having some $2.5 billion of surplus dollars and where we're going to spend it. And we also talk about the growth that we had. So I think we need to kind of, as they would say, slow down, slow your roll, really take a look at where we are, put some things on brakes. We're in no major hurry to pass this legislation. Now, some of you may want to do that because you think it's going to be a popular thing back at home. But real reality, do your homework. Take a look at the numbers, take a look at where we are, and try to figure out, is that the best decision for us? Are we just becoming part of everybody else who want to join in the fight between one party or another party as relates to what's going on in Washington? Thank you, Mr. President. Wanted to share these figures with you. Wanted to let you know we are still not out of the water yet. Just like Delta came through, something else could come through. We could find ourselves again further and further behind with the debt service continuously to grow. I'm concerned too about, can Washington get their act together? Can they do some things that actually make good decisions by working together instead of twisting arms to try to get something passed? That last $1.9 trillion where we paid the unemployment benefits, and there's some real questions we had last week in terms of whether or not we paid our fair share on the state side, wasn't an issue then, because the federal government was giving us additional funding for that unemployment compensation for our people. So our economy continued to grow. Other economies may not have done as well. And so the question is, will we continue to extend things like child tax credits, grants and loans for small businesses to be able to strive? And hopefully we don't have to go back and deal with the unemployment. I think when we talked last week about unemployment, we've got the largest surplus, I think, in the history of benefits in that account than we've ever had. Thank you, Mr. President. I only wanted to share just a few things and really want to talk about what is real. Is it about the money, or is it really about policy?
Thank you, Senator from Richland. Senator from Richland, Senator Harpootlian, what purpose do you rise?
I would like to speak to the amendment.
You're recognized.
Could I also ask, is there a quorum present?
Quorum has been questioned. The clerk will count. "24 members are present. A quorum is present."
Thank you.
Senator from Richland, Senator Harpootlian.
So I've asked some questions of the senator from Charleston. He and I obviously have a disagreement as to what the intention of the founding fathers were. And I think probably to rely on divining what they meant, you would look at Madison's notes that he made during the convention. And clearly, this was not the pristine analysis that the senator from Charleston would have us believe. Now, he concedes that there was give and take, as there always is. But let's understand what we're doing here. And let's understand what we're not doing here. What we're not doing here is sending some folks to a convention with a restricted ability to do, restricting their ability to do what only we say. The amendment on physical restraint and limiting the powers of the federal government is so general, so broad, so all-encompassing, they basically could pass an amendment shutting down the federal government. Now, I think one of the things Senator Scott was pointing to just a moment ago is that we've got a few $1 billion more to spend this year because of the irresponsibility of the federal government. We want the heroin dealer shut down, but we don't want to give up our heroin. So before we get all indignant about federal expenditures, we're the problem. Legislatures that take that money and spend it. I mean, you know, and by the way, we have so much money for roads and so much money for infrastructure now. It's just amazing to me that most of that money came from the irresponsible conduct of the government, of the federal government, by creating more debt. And yet we're going to spend it. And I guess we should spend it, but I think it's somewhat cynical on our part to complain about how they expend the money. They're drunken. Senator from Anderson, that's drunken sailor. You were unwilling to pick out a specific group of people to point to, but that's the saying, you know, drunken sailor. I'm not as politically correct as you are. So, pretty good, huh? Okay, so before we get to the technical pieces of this, just want to point out, let's not act all indignant about excessive federal spending when we're the ones spending it. Okay, let's make that clear. So if you've got some problem with fiscal restraint, I think we need to, a balanced budget amendment, maybe if it was specific, if it talked about, exceptions for in time of war or exceptions for a huge natural disaster, or we have some provisions that would allow the federal government to spend money in extraordinary times. Limiting the power and jurisdiction of the federal government. I don't know what that means. Are we going to have a federal government? Or is it going to be a federal government? And again, you see this, and I will agree with the senator from Charleston, there was this decision about, were we going to have a strong federal government, a weak federal government, strong state government? And by the way, this tension between the rights of the states and the rights of the federal government ultimately, broke. And in 1860, there was actual, I know you find this shocking, war over it. When I was growing up in Charlotte, we referred to it as a civil war. If you were growing up in South Carolina, I think you called it the war between the states. Am I right about that, Senator? In Charleston, war between the states? That's what we called it. Pardon me? Well, and of course, Senator from Richland Jackson indicated to me that's not what he got in his school. But was that a separate but equal school? Okay. It was separate, but separate unequal school, yes. They didn't refer to it as the war between states. So obviously that tension in the late 1700s boiled over. And of course, the major issue in that was not states' rights, but states' rights to have slavery. And as I read you, one of the issues on some folks that voted for Article 5 was this issue of slavery and this issue of giving freed black slaves any vote in elections. So it's complicated, and it's certainly not clear that this was created to allow a subsequent convention, as Madison and others said, bad idea. Now, given that they were very concerned about doing it, now we're going to talk about sending people to, and by the way, how many people? How many people? How many votes does South Carolina get? How many votes does California get? It's unclear. Legally unclear. And basically, I guess we'd decide how many we'd send, and California decide how many they'd send, and then the convention would decide how many votes each state gets. But then the states with the most people there would probably dominate that. It'd be more like Congress than it would be than the Senate in terms of votes. Unclear. So once they got there, would they be restricted to only handle and only deal with the issues that we send them to deal with? And we're just going to talk about, since this amendment only deals with fiscal restraint, I want to talk about it in that context. So the first thing is, it's pretty clear that Article 5 convention be governed by Mason's Manual, the only handbook for parliamentary procedure designed specifically for legislative bodies. And let me explain, there's several elements of Mason's Manual which you may not be aware of. Section 22, right to change rules. All legislative or governmental bodies have the power to abolish, modify, or waive their own rules or procedures. So right off the bat, they could change the rules. They could make the rules whatever they want. So this idea that somehow we're going to restrict what they can do is not based on the rules. It's not based on precedent. It's not based on the text of the Article 5. It's not based on anything but, oh, that would never pass 3/4 of the state. They would be constrained because it wouldn't pass. You know, if these folks are rational people, if these folks are not rabid states' rights people, or whatever you want to call them, you may be right, but I don't think folks who get involved in this process are necessarily rational, because I think this is an irrational response. Mason's Manual, Section 24. Failure of a House or of the legislature to conform its rules does not invalidate its acts. Rule 3, a rule is virtually repealed for the occasion when it's disregarded by those who have power to control it, and the act of breaking it is at least the suspension of it. The fact that a House acted in violation of its own rules or in violation of parliamentary law in a matter clearly within its power does not make its action subject to review by the courts. So, Senator from Charleston, clearly the rules that they're going to operate by says they can't be reviewed by the courts. There is no appeal to the courts. And of course, Section 25, when a legislative body disregards or violates its own rules of procedure, the courts will not declare its enactment void, further affirming a court's not going to mess with this. So Congress, you know, does Congress have a say in the convention? The answer is no. Congress has the important function of calling for the convention itself. Legal scholars have vehemently debated the extent of this authority, but even minimalist interpretation would assign a critical role to Congress. It could call for the convention, then impose minimum requirements on the convention to its form, procedures, and agenda. Congress would then be responsible for referring proposed amendments to the state. It's unclear whether or not Congress would have any control beyond that. So this idea of one state, one vote hasn't been borne out by any studies that have been done. The likely scenario is states would be allocated votes based on population. So, Senator from Anderson, Massachusetts, California, Illinois, big populations. There goes your Second Amendment. Gone. No guns. Scary. So, if it's by population, the East Coast, if you will, the Northeast, California, Colorado, some of these states that already have enacted pretty strong anti-gun, anti-Second Amendment, would perhaps have the ability to put in and repeal the Second Amendment, or at least effectively modify it. Now, the other thing, and by the way, does California get the same vote as Wyoming? Probably not. Does South Carolina get the same vote as California? No, probably not. And, you know, I say probably, Senator, because I'm using the same standard you used when you said what would happen. Probably. Probably. We don't know. We're buying a pig in a poke. Nobody has any idea what's going to happen. It could be, and of course, the bailout is, you know, will 3/4 of the states ratify it? Who knows? Probably not. Probably. And so what are the odds? 90%, 60%, 80%? Nobody knows. So this is going to make everybody go to this convention. They're going to politically put pressure on, if they pass something, to put the votes together by the states. And by the way, each state does have one vote in that 3/4, right? 75% of the states, not 75% of the population. So California counts as much as Alabama under that. Now, the other thing is that this idea that we're going to pass a criminal statute making it a criminal offense if a delegate goes outside the bounds of their commission, that happened in 1787. Nothing happened to those guys. So road delegates would most likely be immune to prosecution by state entity because state legislatures have no authority to control representatives in Article 5 convention. Delegates to a federal convention are called by federal Congress to perform federal function of altering or replacing the Constitution or performing a federal function, not a state function, so we don't have the authority to impose any criminal sanctions on them. So I guess what I'm saying is this: why are we doing this? Because people have a minority of a minority in many of these areas that are demanding this. They're sitting out in the lobby still, people dressed like Uncle Sam, thinking this is their patriotic duty. I mean, what's really? You know, it's like those conventions I went back to in the 70s when people wore hats. Remember those hats? People wore these hats, came in buttons, and because it was like a party. It's not so much anymore. It's a pretty serious affair. It's boring. So what I would say to you, and that these folks think that somehow that this process is going to result in something other than a political sideshow. I think not. You know, matter of fact, Senator from Charleston, I thought for a while, why bother? Because this is an exercise in futility. It's going to pass. It's going to pass because you're afraid of your constituents. Somebody in a primary could primary you because you voted against the Convention of States. That's all this is about. Now, I, on the other hand, challenge somebody to run against me in a primary or a general election over this, or my vote against anti-abortion, or my numerous votes that are offensive to many of my constituents. Please run against me. Get me out of my misery. Term limit me. So I guess the bottom line here is, and I've got a whole, maybe I'll save this for further on. There's all kinds of great quotes from Madison and Hamilton about why you do this or why you don't do this. Nobody cares, at least at this point, maybe later on tonight, but not right now, about those issues. And maybe when we come to, as I understand it, we have this amendment. There are 5 or 6 other amendments. We're going to have plenty of time to talk about this. But really, you know, why don't we just move on and do something constructive? We got anything constructive to do this week? Next week? Senator from Lexington, move on? Okay. Well, I've got another out.
Senator from Richland, Senator Jackson, what purpose do you rise?
Mr. President, with the senator, my friend, you for a question.
I will.
Senator Hughes for a question.
I almost made it. I thought I would get by this whole debate, not say anything. It was hard at one point, particularly, and I'm such a fan of the senator from Charleston and his history and others, but y'all have heard me say this often. I come from a family of historians. My uncle was a historian, and oftentimes when we talk about the founding fathers and how great they were, it takes a lot in me sometimes, a whole lot, just to sit still, particularly when you invoke the name of Jefferson. There's some folk that would probably like to give a different opinion, and their wisdom with the Constitution and some of the things in the Constitution. I guess my question to you is that, in the wisdom of all of these great people, how did my ancestors fare in the Constitution? How were we considered?
Well, you were considered when they needed something cold to drink or something to eat, because you were the folks that brought it. And the only time you were allowed into the Constitutional Convention was to bring food or drink. And matter of fact, when you look at read Madison's book, there was this fear that somehow that states would be put in a position of treating African Americans as citizens. And again, the senator from Massachusetts was offended by the fact that freedmen would get, I think it's 3/5 of a vote in any. So how were they treated? Badly, like property.
Senator, have you ever heard of the book, The Prostrate State?
I've heard of it. I haven't read it.
It's an interesting book that I have, and I'll be glad to share it with my colleagues. New York Times author and writer comes to South Carolina during Reconstruction, and he describes the South Carolina General Assembly, and he describes the leaders of South Carolina at that time. Wouldn't it be interesting to have had a state convention then. Are you aware that in 1860, when Fort Sumter was fired upon, a majority of the population in South Carolina was African American, or just say people of color?
I was not aware of that.
What about 1865, when slavery ended? When slavery ended, a majority of the population in South Carolina, Senator from Charleston knows this, they were people of color. Were you aware that in 1870, a majority of the people in South Carolina looked like me? 1875, 1880. I have the census data with all of that. Fortunately, I told you, being from a family of historians, we can trace our ancestors back 7 generations of slavery, even back to my great-great-great-great-grandfather was born in 1775. 1775 in Richland County. And so it's hard sometimes when you sit and you hear all the accolades and all the glorious comments made about our state and our founding fathers and how great they were and all the wonderful things that they accomplished without any acknowledgement of their frailties, of their faults, times when they really got it wrong, really got it wrong on that. And so those are the things that I think sometimes drives some of us. And recently I've been very quiet on the subject and just saving all of my ammunition until we get to critical race theory. I've got some really good stats to share then, really, really great stats. One is the congressional records. Have you heard of the congressional records of actual testimonies of slaves? Went to Congress, Ku Klux Klan hearings and others, and they actually gave their, these aren't theories, these are testimonies of people from South Carolina with names and faces. So we're gonna have a good time at the appropriate time when we sit down and get an opportunity to really talk about that. But all of those things matter when you talk about history. And so, as my late uncle would always say, that history is usually his story. That's what history is. And it's usually the person who's telling the story. And that's why we have something. Have you ever heard of the lost cause? Lost cause after the Civil War, that historians got together and decided, well, the war really wasn't about slavery. It was about states' rights. And it was about Northern aggression. And all of those things are things that are really part of our history here in South Carolina. And when we, and I guess when we talk of constitutional conventions and all of that, it just brings back people like me, just historical memories passed down by generations of ancestors. And I'm fortunate. I am fortunate because I am one of the few African Americans whose ancestors passed it down literally and wrote it down. And so we know, and we've got documentation of all of that. But all of that matters, I guess, when you start talking about the wisdom of those who were so brilliant in shaping our discussion here today. Just a few things I thought that as we prepare to end this for the day, hopefully that we just throw out, and maybe at some later time I'll get an opportunity to take to the well and really educate us on South Carolina history with documentation, with documentation, slave records, testimonies, people who served in this body. You ever heard of Reverend Richard King?
Yes.
Richard King, senator from Charleston. Where's my senator from Charleston? Senator from Charleston, pastor of Emmanuel AME Church. Great guy, served in this body. Name never appears in South Carolina history books. Never appeared. I mean, I went high school, graduated from Drill High School, and others, never appeared in South Carolina history books. Great people. So all of those are things that I think that when we start having these kind of discussions, that just understand that there are other sides of the story that perhaps, not perhaps, but I'm sure needs to be told also. So thank you, Senator.
Thank you, Senator. And I think to elaborate on the Senator's comments, certainly understand context of his feelings. A Constitutional Convention held by all white men, many slave owners, and interestingly enough, one of the really harshest commentaries about slaves was from a representative from Massachusetts. So it wasn't a Southern versus Northern issue in 1784. I do think, and it's I think this is an issue, and I hate that it's coming up at this late hour in this context, but many of us, white folks, forget context. Let me put it a different way. I am of Armenian heritage, the name Harpoulian. My grandparents came to this country because when they worshiped as Christians in Armenia, the Turks killed 3 million of them. They escaped a genocide. Hitler in Mein Kampf said the Turks were brilliant in what they did with the Armenians. They just weren't efficient about it. They had to waste a bullet on everyone. So I understand context of that history. And only recently has this country even recognized a genocide. The Armenian genocide was recognized 2 years ago. I had an aunt when I was about 6, I remember, who was in her 80s at that point, that told stories about the Turks coming into her town and throwing babies up and catching them on bayonets. I mean, it was a horrid story, 6 years old. My point is this, that history, that context was not recognized by any of you because you're not of Armenian heritage. It's not appreciated because you didn't live it. I didn't live it, I heard about it. But it still affected, I mean, it affected and I've tracked my folks had lived in Armenia going back until 1000 AD. That's how far back the records went. Armenia is one of the oldest countries in the world. And so they had to leave because of religious persecution, genocide. But I don't appreciate that. I don't, when I say appreciate it, I don't understand it. I don't have the context for it. And so when I get called by some Armenian folks around the country that know I'm in the Senate here and have had some access to Presidents Obama and Biden, they are exasperated with my inability to connect with them. I just got to tell you, I mean, I wish I could tell you I've been aggressive about pursuing this. I haven't been, because it's not my experience. Many of you, and in terms of your experience, I am relatively new to South Carolina, 50 years. It's hard for me to appreciate his experience, his family's experience, and for those of us that want to say that, you know, if you're an American, you know, you can, in this country, you can be whatever you want to be, it's not been exactly true, not true for people of color, for a whole variety of reasons, many of them not of their own making. I believe that we as a society, whether it's the church or government, should assist those, make sure those children that can't get fed, make sure those children, Senator, when we talk about abortion coming up, I mean, where's the prenatal care? Where's the postnatal care? Where's the daycare for these children to make sure that somebody who's making a choice about having that baby or not having that baby understands that baby will be well taken care of? Where are those choices? Many of those folks that choose that route are African American. Many of them do it because they can't afford the medical or the daycare, and they can't afford another child. Those are decisions we need to make. It's not our experience. When you go back to your communities, if you're like me, I live a quarter of a mile from here in a really nice house, and I drive a really nice car, and I have a really nice office about a mile that way. And I don't see what people of color in this community see on a daily basis. So I try to reach out and try to figure out how we can help them. But this constitutional convention, I'm afraid, Senator, will be just as white as the one in 1787, maybe whiter. I've looked out in the lobby. I ain't seen a bunch of black folks out there campaigning for this. So it may be, although there is a provision, as I understand it, to make sure that it's representative of the community gender-wise and race-wise. I've read that provision, but it may just be a bunch of white folks going somewhere to do a convention again, and hopefully African Americans play a bigger role than delivering the drinks and bringing the food. So, time is it? 5:45.
Senator from Charleston, Senator Gibson, what purpose you rise?
Senator from Richland, yield.
For a question?
Yes.
For a question. He yields for a question.
Senator, first of all, I thank the other senator from Richland for educating us on, giving us a history lesson as well. But I kind of want to shift the focus, not to minimize that conversation, because I think we're coming back to that at some point, the history of the Constitution and the impact on African Americans. But something that the other senator from Richland, Scott, mentioned earlier was with respect to the impact on this fiscal constraints would have in a country during the time of war. And I listened to you as you talked about your wife, who is really in a combat zone. How does this play out when we are putting handcuffs on the federal government in the time that we need the resources of the federal government to participate in organizations like NATO? You know, there was an effort by the previous administration, President Trump, to essentially gut NATO. I think he spoke very negatively while he was palling around with Putin in disrespect of NATO. What does it mean to have constraints on the president of this country as we make a decision to go to war and protect our allies who are supportive of democracy around the world and supportive of human rights?
Well, I think that, I mean, when you say put handcuffs on, that's what concerns me about this language of a physical restraint. Why wouldn't we pass specific language saying balance the budget, you know, over a period of years, can't spend money that exceeds whatever that phase-out limit is, except in times of war or some natural disaster, okay? Huge natural disaster. I don't understand why we wouldn't make it that specific. And then, you know, if they vary from that, I still don't think we can do much about it. But at least we send them with the specific instructions. And perhaps if they do vary from that, we could take the position they did not. We wouldn't. This state would not ratify it because they didn't do what we asked them to do.
Sure. So is it your view that this would essentially tie Congress's hands to appropriate money
Yes.
for missions saving Ukraine from Russia?
Not only would it do that, let's think about what happened during COVID. Many businesses would have failed had there not been the money created to give them grants or loans, most of which were forgiven, to keep their doors open, to pay their employees. We had a pandemic. We had a plague. It was shutting this country down. And there was a lot of money, close to $1 trillion appropriated to keep the doors open. And we were just a few weeks ago bouncing back from all of that when war broke out. And that's tanked the economy at this point anyway. But without that help, just like Roosevelt with the WPA and the other programs during the Great Depression, if we don't have the ability to do that, if those are not programs that could be exempted from any sort of fiscal constraint, we're in deep trouble. And we couldn't prosecute a war. I mean, I just read a Republican senator proposed a $1 trillion defense budget. $1 trillion. That's a lot of money. That is not fiscal restraint. So do we cut back on our defense expenditures? Do we say to Russia and China that we're going to do defense on a shoestring budget? At any time in our history in the last 50 years, we needed, I was not a big supporter of the second Gulf War, the weapons of mass destruction. I was not a big supporter of Vietnam. I was not a big supporter of what we did in Afghanistan. I mean, the soldiers did what they were asked to do, but I thought we took our eye off the ball. But we spent $1 trillion, or I wish Senator Scott was here, trillions of dollars on that. And there was no congressional authorization for that.
Do you think that the people, first of all, do you know who we send into this convention and where this convention will be held? Does is it going to be in Yamasee, South Carolina, or is it going to be?
Nobody knows. And if you look at all the people with the funny hats and the badges on out there, I bet they want to be delegates.
So with respect,
by the way, that instills confidence right there. People with the funny hats out there.
I think they're going to be waiting on you.
I'll take the back elevator.
Well, that raises a point. So let's assume, which is a big assumption given the gaps in this poorly worded resolution. I mean, this is I don't know who drafted it, but it's poorly worded.
People out there.
Let's assume what the senator from Charleston represented to us, that it's tightly, narrowly crafted so that the delegate from Yamasee who goes to, wherever on our behalf, this passes and he or she goes on our behalf. Do you think that they understand, or is there anything in the bill which requires some education level with respect to voting on times of war period or times of pandemic?
No. And 2 points. Interesting question you have. First of all, why do you pick Yamasee? That's sort of interesting to me. Is there something wrong with the people of Yamasee?
No, I just point that out as a place in South Carolina.
You could say any other place. Whose district is Yamasee in? Who's got Yamasee? Margie's got it? Well, if Margie's watching, you're going to catch it when you get
there. I love the Yamasee. I just use that as example.
Okay. Interesting concept. Who's going to pay for them to go? Are we going to appropriate money to send these folks to Montana or DC or Philadelphia, wherever they go? I hope not. They're citizens. They're not full-time politicians like people in DC. They should pay their own dime. They go there on their own dime. Take a bus. It'll get them more in touch with the common person.
And I guess more substantive question on that point is, will they be required to sit down from the senator of Charleston and the committee who came up with this, who proposed this to judiciary, to receive some instruction with respect to the limitations that are not present in the resolution?
They may, but they're not binding on them. They can walk out and do whatever they want.
And I think I heard that there were some criminal penalties attached if they go rogue.
They're going to be. Let me make sure everyone understands this. Let me get my glasses back. Delegates to a federal convention called by the federal Congress to perform federal function or of altering or replacing the Constitution or performing a federal function, not a state function. We don't have the authority to penalize them.
So
or any other way.
So no penalty for going rogue.
No, go rogue.
And really, with respect to how the legislation is drafted, it's very broad. So if they hire, let's assume there is a criminal penalty. They hire a good lawyer like Senator from Richland, then you got a lot of wiggle room
just
to,
don't-
to get them off of the charge, right?
I don't, well, no wiggle room. I mean, I just don't think you can prosecute somebody performing a federal function and say it's a state crime. I just think that's constitutional law 101.
So in fact, they can go to this constitutional convention and do anything they want.
They
essentially.
could repeal the Second Amendment. They could repeal the 14th Amendment, although there's some language about you can't do the 14th Amendment. It's not binding on them. They could reinstitute slavery. They could do away with your right to hold, to possess a gun or own a gun. They could do whatever they wanted to do. Now, the check and balance on that is, would 75% of the states agree with them? Well, who knows? I mean, it's crazy out there. I'd hate to put my faith in what may or may not happen in a state. I mean, this is probably something that's 2, 3, 4 years away. Things could change dramatically.
So we talked about earlier the money that was sent by the federal government. Do you remember how much was sent to South Carolina during the pandemic from the federal government?
Several $100 million.
Would it surprise you? $13 billion? Billion?
13, B with a billion?
Billion.
It would not surprise me because I just remembered we supplemented everybody's unemployment. That was a bunch of money. And then again, you could get loans up to
So
billions
if you
of
count coronavirus, the coronavirus first package, 1, 2, and I believe there was 3, and then there was American Rescue, which was about 18 or 8 billion.
right.
And I believe we spent some of that. I believe 2 billion last week, and there was no discussion about sending that $2 billion back. Did you hear any discussion about that?
Nope.
And so that's an example of us being what I call hypocritical.
Well, I mean, if somebody robbed a bank and left the money in your room and you kept it and you maybe that's a wrong analogy. Yeah, it's hypocritical.
Yeah, and what surprises me is we get back to the discussion that you had with the senator from Charleston a few minutes ago, or earlier with respect to term limits. I've never heard anybody in here propose term limits. Personally, I'm not a career politician. Did you know that?
No.
But I would gladly support state term limits because I don't plan to be here for a very long time. And I'm not going to define very long time. But
And Senator, I think you've made a statement today that's going to make some folks in here sad, some folks in here not so sad.
But I just find it interesting that we're so fired up now about sending money or constraining the federal government from bailing out our inept leadership during a pandemic. We kept the money, and this resolution calls for term limits, and no one has offered term limits. I believe the senator from Richland, McLeod, has actually offered term limits, but we don't for state officers. But yet that's not on the Senate floor. Did you know that?
I did not.
So I'm interested in hearing more. I know you're planning to talk pretty late into the evening, and I believe the senator from Williamsburg has a number of different amendments, but I'm interested in hearing more about your perspective on how this bill would impact negatively South Carolinians.
Okay. Let's do it. Let me, first of all, again, review how this convention came to be in 1788. On September 22nd, 1786, political figures, including James Madison, Alexander Hamilton, met in Annapolis due to the inadequacies of the Articles of Confederation. Now, the Articles of Confederation haven't gotten a lot of discussion here today. We can spend an hour or two just on the Articles of Confederation if you wish, but Senator from Cherokee is giving me the look that indicates to me that he's not really interested in the Articles of Confederation. If you insist, I will go into them. But when they met in Annapolis, due to the inadequacies of the Articles of Confession, the result was this call for a constitutional convention to take the Articles of Confederation, which, by the way, did not have anything like Article 5 in them, and have a convention. There was a call for the Continental Congress, then situated in New York, to call a convention. As a result of that call, on February 21st, 1787, the Continental Congress reluctantly called for a convention for the sole and express purpose of revising the Articles of Confederation, and he instructed the states to choose their delegates. Now, the delegates are chosen by the states, and they were so instructed. And the convention convened on May 2nd, 1787 in Philadelphia, as set by the Continental Congress. So that went according to plan. What happened next, however, was not. Also why the Continental Congress was reluctant to call a convention. Once the convention was convened, the delegates set aside their instructions, set aside the Articles of Confederation, and wrote a new constitution, what we now know as the United States Constitution. So let's get this straight now. The original Constitutional Convention was authorized by Congress. States picked their delegates and sent them to Philadelphia to amend or revise the Articles of Confederation. That's not what they did. They set aside their instructions, set aside the Articles of Confederation, and wrote a new Constitution. The new Constitution had its own method of ratification, Article 7, as did the Articles of Confederation, Article 7, as did the original Articles of Confederation, Article 8. There's nothing to stop any of this from happening again, which is exactly what happened the first time around. They rejected their instructions and went on their merry way. So I think it's important to understand. Sure.
Senator from Charleston, what purpose do you rise, sir?
Senator,
Senator yields for question.
Senator, would you yield for a question?
Sure.
I've heard about from several sources, the Constitution itself being the product of a runaway convention, which is kind of what's being alluded to here. And did you know I did some research, and I'm holding in my hand an act authorizing the election of delegates dated March 8th, 1787, passed by the Senate of South Carolina and the House of South Carolina. John Lloyd, President of the Senate; John Julius Pringle, Speaker of the South Carolina House of Representatives. March the 8th, 1787. This is the resolution appointing delegates to the so-called runaway convention. So-called, yes, because this is going to demonstrate that it is so-called. This is the power that they give to the delegates. They are duly authorized and empowered in devising and discussing all such alterations, clauses, articles, and provisions as may be thought necessary to render the federal Constitution entirely adequate to the actual situation and future good government of the Confederated States. That is not a limited power that they were given. And so and Senator, did you know that this is what the legislature of South Carolina passed, and under further research, there were only 2 of the 13, there were only 2 of the states that had, that actually didn't have this kind of broad authority to do anything, basically. And so the notion that it was a convention that ran away because it adopted the federal Constitution and realized the Articles of Confederation just wasn't in a structure that would work, which thank God they did do that, but fully authorized to do that in this resolution passed by the South Carolina General Assembly.
Well, Senator, did you know that on February 21st, 1787, the Continental Congress called for a convention, quote, for the sole and express purpose of revising the Articles of Confederation. Now, if South Carolina had something different than that, that was the beginning of the runaway convention. That was the start of the run away, if you will. I mean, that is not consistent with what they instructed to do, which makes my point.
No, it doesn't make your point. So you're talking Congress. You're talking about these delegates to what became the Constitutional Convention were authorized to take whatever action necessary by the South Carolina State Legislature,
right,
to render the federal Constitution entirely adequate to the actual situation and future government of the Confederate States. There's no limiting language at all.
which is inconsistent with what they were instructed to do by the Continental Congress. That's my point.
This is an Article 5 Convention of the States, is what we're talking about.
There was no Article 5.
I know, but we're talking about an Article 5 Convention of the States, and you had the states give their delegates this kind of plenary power.
The convention was not an Article 5 convention. They were simply instructed by the Continental Congress to come and revise the Articles Confederation, the Articles of Confederation.
But that's not what we instructed our delegates to do, is the point I'm making.
Well, now we're under Article 5, different.
Yes, we are, but the notion that the delegates were run away is not accurate, because they were authorized by the state to do this.
But not authorized by the Continental Congress to do it.
The state is what they were subject to, the authority of the state.
Well, because
because they were delegates of the state.
Because we didn't have a constitution. And one of the big, as you know, from reading Madison's work, the big question was, why do we need a federal government? I mean, that was sort of the initial, do we really need one? Can't we just sort of do what we've been doing?
That is correct.
And so they may have been instructed to do that. As you indicated, other states were not. They all came with different.
All but two had this kind of broad authority, actually.
Well, two did not. You would at least concede that.
Yes.
Okay.
Yes.
And they were instructed to do, to deal, express purpose of revising the Articles of Confederation. So that's not what they did. That's what the Continental Congress gave them authority to do.
But they acted, our South Carolina delegation and other states except two acted consistent with what their state general assemblies or legislatures instructed them to do.
But inconsistently with the Congress.
Inconsistent with
the instructions given to them by the Continental Congress.
Yes.
Okay.
But consistent, but we're given instructions here from the state level now is what we're doing.
Under Article 5.
Correct.
Well, there was no Article 5.
No, that's true. There wasn't an Article 5, but the history is that the delegates acted consistently with what the state legislature, the directives that the state legislature gave them. And we're giving directives in this.
But which they don't have to follow.
Well, I mean, you can violate a law or you can violate the state law, but there may be judicial review of that violation.
Not according to Mason's rules.
Mason's rules is talking about how a legislative enactment or a legislative process, the internal process of the legislature is not subject to judicial review, but
how would a court
the process, like there's no judicial review for points of order made in this chamber.
Correct.
Or whether a bill even somehow got passed without a point of order being made that it was subject to. It's the enrolled bill rule. Once a bill is enrolled into law, our state Supreme Court has recognized it many times. Once a bill is enrolled for ratification, any challenge to it based upon any kind of procedural matter is then moot. And so I think Mason's, what you're talking about, is probably addressing that same issue. This is in the legislature's
issue at the convention. They don't have to follow their own rules. There's no judicial appeal from what they do at the convention.
There's no judicial appeal in Masons is talking about legislative bodies. The House uses Masons. We use Jeffersons whenever our Senate rules don't directly apply. The House uses Masons whenever their House rules don't directly apply. And Masons is a rule of procedure, a default backup procedural rules of procedure for legislative bodies that adopt it, like the House did. But really, I think what you're just describing is something tantamount to the enroll bill rule. Once the legislature has acted, no one stands in judgment over whether the procedure was properly followed or not within that body.
Well, what I'm saying is this. If our delegates go up there and go off the reservation, repeal the Second Amendment or do something, repeal the 14th Amendment, whatever, that can't be, what they do within that context can't be appealed to a court under Mason's rules, what they pass.
They're not a legislative body. They are a convention called in order to propose amendments to the Constitution. That is not a legislative body.
But they're going to use Mason's rules for procedure.
Well, I don't know if they're going to use Mason's rules or not.
That's my understanding. But okay, so let me move to the next point.
I'm just saying this is an issue particular to legislative bodies.
If a delegate we send is going there pursuant to federal authority to deal with the federal Constitution in a federal context, do you think a state law can inhibit him or her?
Yes, because the state initiates the process. The states initiate the process. Sure. They elect delegates. They send delegates to the convention, to produce a proposed. They're not exercising any federal authority. They're proposing this authority that the Constitution gave to the states for the states to have a way to propose amendments to the federal Constitution. They are agents of the state, not of the federal government.
Interesting interpretation, but that's something I guess.
Well, the framers put it that way. I mean, I quoted Madison and Hamilton, and they talked about it that we provided two ways to amend the Constitution. One is Congress, and one is the states.
The question is whether they become a federal operative once they go participate. And look, we can debate this all day long. I think they are. You think they're not?
No, I think they're not. Yes, you think they are. I think they're not.
So you'd be defending them in court, and I'd be prosecuting.
Well, Senator, I don't treasure the idea of being in a court of law with you, but if I have to, I will. But I don't treasure that. So.
I think it would be fun. You looking at me? So a couple of other things I think I want to talk about. Where is what I'm looking for? Okay. So when you look at a group called the Avalon Project on Federalist number 43, which is Hamilton, it says to provide, what they talk about is the context of Article 5, to provide, quote, to provide for amendments to be ratified by 3/4 of the states under two exceptions only, that useful alterations will be suggested by experience but could not be foreseen. It was requisite, therefore, that a mode of introducing them should be provided. The mode preferred by the convention seems to be stamped with every mark of propriety. It guards equally against that extreme facility which would render the Constitution too mutable, and that extreme difficulty, which might perpetuate its discovered faults. It moreover enables the general and the state governments to originate the amendment of errors as they might be pointed out by the experience on one side or the other. The exception in favor of the equality of suffrage in the Senate was probably meant as a palladium to the residuary sovereign of the states, implied and secured by that principle of representation in one branch of the legislature, and was probably insisted on by the states. So what they're saying here is that you can amend, that you can, once it gets there, you can do something other than you were sent to do. I think it's important to understand
Stand at ease. The Senate will stand at ease momentarily. Senate will come to order. Senator from Richland has the floor.
Do you have a question?
Senator from Edgefield, Senator Massey, what purpose do you rise?
Mr. President, I have a few unanimous consent requests with the senator from Richland holding the floor.
Senator holding the floor, state your request.
My first request, Mr. President, is with the senator holding the floor that we invite the House to ratify acts.
Is there objection? Hear none? So ordered. At a mutual agreed upon time.
Right. Mr. President, with Senator from Richland holding the floor, I ask unanimous consent that if and when the Senate adjourn today, that it adjourn to meet at 12:15 tomorrow so that we can gather for the joint assembly. And then at the conclusion of the joint assembly, that the Senate would stand in recess until 2 p.m.
Is there objection? Unanimously adopted.
Mr. President,
Senator from Edgefield.
I ask unanimous consent, and if the senator needs to give up the floor for this, that may happen, but I ask unanimous consent that we adopt the committee amendment.
Unanimous consent is that the committee amendment be adopted. Is there objection? Hearing none, so ordered.
Mr. President, my next motion is going to be that we adjourn with the senator holding the floor on the First Amendment. But before I make that motion, if there are other senators who have unanimous consent requests or some type of an announcement for the body, I would invite those at this time.
Senator from Edgefield, thank you. And as our president, let me just say that we've just accepted the national commander of the American Legion to be our guest. I would hope that tomorrow we will all be here for that opportunity to hear from our veterans in our American Legion. Please give them that courtesy for 30 minutes. Senator from York, Senator Clymer, what purpose do you rise?
To make a brief announcement.
State your announcement.
Senators, tomorrow is the annual American Cancer Society Day where we're asked to wear our tennis shoes to work. So please wear your tennis shoes tomorrow for that occasion.
The body is so informed. Senator from Lexington, Senator Shealy, what purpose do you rise?
Unanimous consent request to make a brief announcement.
State your request. State your announcement.
Tomorrow is National Alzheimer's Day, and I would like to remind everybody that this will not be very hard for you to do, but it's Wear Purple Day. So wear purple in honor of those suffering from Alzheimer's.
We're so notified. Thank you for that announcement. Senator from Berkeley, Senator Grooms, what purpose do you rise?
Unanimous consent to recall a bill from the Transportation Committee.
State that number.
Unanimous consent to recall Senate Bill 1085. It's a road naming bill in Marion County, and have it placed on the calendar.
Placed on the calendar. Unanimous consent to have 1085 from Transportation Committee and placed on the calendar. Is there objection to that unanimous consent request? Hearing none, so ordered. Senator from Marion.
Unanimous consent request.
State your request.
The bill that was just recalled by the chairman of Transportation as 1085, I would like to apply the role of the Senate to that resolution.
Is there objection to the role of the Senate being applied to the resolution? Hearing none, so ordered. The role of the Senate will be applied. Senator from Horry, Senator Rankin.
Unanimous consent request to recall a number of precinct bills, and I can list those for you.
State your request there, okay?
S 953, Senator Burden from Lawrence. S 1024 from Horry. H 4495, H 4269, and S 1060.
One at a time. Unanimous consent to have S 953 recalled from Judiciary and placed on the calendar. Is that your request?
That is.
Is there objection? Hearing none. He renews the request on 1024. Is there objection? So ordered. To renew the request on 4495 to be placed on the calendar, discharged from Judiciary Committee. Without objection. 4269 to be recalled, placed on the calendar, 4269 without objection, and 1060 to be recalled and placed on the calendar without objection. Senator from Richmond, Senator McLeod.
Request.
State your request.
Leave for the senator from Colleton for the remainder of the week.
Without objection. Senator from Lawrence, what purpose do you rise?
Unanimous consent request.
State your request.
Call 942, Senate resolution from the committee. It's a bill recognizing osteopathic medicine day for tomorrow, March 9th. I ask that it be given immediate consideration.
Is the objection of recalling S 942 from the Medical Affairs Committee and giving it immediate consideration?
Mr. President.
Senator from Lawrence.
S 1005.
You're substituting S 1005 for that unanimous consent. Is there any objection to S 1005 being recalled for medical affairs and given immediate consideration under the definition as presented by the chairman of the committee? Hearing none, 1005 is recalled and is unanimously adopted. All the friends. Senator from Richland, Senator McLeod, what purpose do you rise?
Parliamentary inquiry.
State your inquiry.
What is S 1005?
That is
President.
explanations requested. Senator from Lawrence.
Thank you, Mr. President. Senator from Richland, S 1005 is a Senate resolution recognizing Osteopathic Medicine Day tomorrow, March 9th. I believe a delegation of students and administrators from the VCOM College of Osteopathic Medicine from Spartanburg will be visiting with us tomorrow.
Thank you. Thank you. Are there other requests? Everybody's standing. I thought they had a request, but maybe they're ready to go.
Mr. President.
Senator from Edgefield.
Mr. President, are there any bills in the box?
There are. Yes.
Mr. President, with Senator from Richland retaining the floor, I ask unanimous consent that we read the box.
Is there objection? Hearing none, the reading clerk will read.
Introduction of a bill by Senator Camp, Senate Amendment Code relating to the maximum sales tax so as to include livestock trailers.
Finance Committee.
Bill by Senator Loftus, Talley, and others. It's to enact the Audiology and Speech Language Interstate Compact Act It amends the code relating to speech language pathologists and audiologists, adds an article, outlines state participation in the compact.
Medical Affairs.
Introduction of a Senate resolution by Senator Hembry. It's to commend the Rotary Club of Little River for its exemplary efforts to educate children and their parents about water safety, encourage all citizens of this great state to become better informed about prevention of child drowning and the practice of water safety, and to declare Saturday, April 2nd, 2022 as Josh the Honor Water Safety Day in South Carolina.
Fish, Game, and Forestry Committee. The desk is clear. Senator from Edgefield, what purpose do you rise?
Mr. President, with the senator from Richland retaining the floor on the First Amendment, I ask unanimous consent that the Senate do now adjourn.
Is there any objection to the Senate do now adjourning with the senator from Richland holding the floor on the First Amendment? Hearing none. Without objection. So ordered, and we are adjourned to meet at 12:15 tomorrow, 12:15.
Well, you have been watching a very lengthy special edition of COS Live, where we've been watching a heated, at times, debate on the Convention of States resolution in the South Carolina Senate. The Senate will reconvene tomorrow at 12:15 p.m. Eastern Time, as you see there on your screen, and we expect them to take up the resolution again on second reading, and then we're looking for a third reading on Thursday. So hopefully we'll have a final action by the South Carolina Senate this Thursday. The Senate has just adjourned for the day. The resolution is still there, and an anti-Convention of State senator was the one speaking last, and it was quite interesting. At times, some of us were wondering if we were still hearing discussion about the Convention of States, because some of the questions and comments wandered way off topic. It was a little bit crazy, went all the way back to discussion of the Civil War and talking about COVID and all kinds of things. It seemed like a true filibuster. So in the interest of keeping you from any further filibuster type activities, I'm going to wrap up our coverage for now, and we will see you back here tomorrow. It might be around 12:15 Eastern Time when the Senate intends to convene again. But if we get word that we are being pushed down the calendar for any reason, it could be a little later than that too. But thank you for watching. If you've been watching our coverage and have questions about what's going on or what this is all about, I would encourage you to go to our website, conventionofstates.com. You'll find all the information you need there to get involved and to make a difference and to be part of the fight for liberty and the restoration of our republic and our constitutional foundations. So stay tuned for more from the South Carolina Senate tomorrow. Have a